May your lordships kindly leave to mention, your lordships. I know, your lordships, once your lordships, the slips to be filled. Well, only ex parte decree passed, matrimonial suit, 90 days will be done, your lordship, on 23rd May. I filed an order 930, order 9 rule 13. No ad interim order passed. Against that, I have before your lordship. I'm just affirming, and tomorrow it will come, your lordship, if your lordship allows me only. If the remarriage is done, your lordship, let me take a chance, your lordship. Let me just file it and give the number, your lordship, to the court. I'm grateful. Number to Didi. I'm grateful.
My lord, may I mention one matter of urgency? Yesterday I take leave, my lord. I file it.
File it,
Well, let it
and give it.
My lord, already filed. Let it be leave tomorrow.
Write your grounds of urgency and give
Let
it.
it be tomorrow, my lord. Let it tomorrow.
My lord, item
My
number.
lord, may I have your lordship's kind leave to
Yes.
mention item number 22? My lord, first, I tender my unqualified apology. For the reason, my lord, I mentioned this matter on Monday.
Yes.
And my lord, we had the impression that the matter would be listed yesterday, somewhere at the first 20-30 matters. But unfortunately, my lord, it was appearing as item 236 or something like that. Yesterday, it is appearing as item 22 today. My lord, today, my lord, this matter I cannot do, my lord, online. My lord, can it be immediately after vacation, my lord?
On the
May it
reopening
Well,
day, at
I'm
the same
sorry, my lord.
position.
I again tender my unqualified
No,
apology.
not at
Again.
all.
On the
Because
reopening day, at
whenever,
the same
Mr.
position.
Majumdar, whenever matters are mentioned, I plan my list
Well,
accordingly.
I am so sorry, my lord. I am so sorry, my lord. I have disturbed
Once
the
it is
business of the
mentioned, the
honorable.
party is supposed to be in the know that it has been
Absolutely.
mentioned, it may be upgraded. on
Yes,
any
yes,
day.
yes, yes.
Not
I'm
of the
sorry.
party choice,
That
but
is why, my lord. That is why, my lord, I'm deeply
If
sorry,
it
my
can
lord.
be at the same, under the same heading, my lord.
very well.
My lord,
Under the
may
same
I have my
heading,
lord
my
sleep to mention item 309, my lord, today's list, my lord. I'm praying for upgradation, my lord. This and
Give your grounds and
My lord.
write it. on the-
May I, my lord, may I have your
Very well. 39. 39 after vacation.
May I have your lordship kind leave, my lord, to mention this matter. This matter was taken up on 18th, as your lordship may remember. Your lordship was pleased to
Remember.
my lord, your lordship was pleased to fix this matter on today's upgraded motion, my lord. But this matter has not.
Very well. দেখে নিন কেন আসছে না না এলে চলে আসবে।
My lord, order আছে, জজ সাহেবের order আছে। আজকে আসবে upgraded motion.
এটা তো ছিল।
That matter was appeared under the heading, my lord, extension of interim order.
It was supposed to be there. Yesterday the file was shown. তাহলে কেন নেই? It is appearing as extension under the heading extension.
Today, not
Yes.
yes.
It's there under the
But
heading.
my lord was directed to
Very well.
very well, man. Very.
Lordship, may
Please hand up your slips and let the court proceed now.
One humble prayer, my lord.
Item number 9.
And this interim order has expired in the end of April, my lord. We have filed an application. It was mentioned on 18th, my lord.
Why is it not appearing as extension? ওটা extension এ দিয়ে দিন।
Lordship, may I be permitted to leave without certified copy?
There's a can one.
Why
my lord, we have served.
when was the
It is
order passed?
re-imposition করতে হবে। interim order expire করে।
18th May 2026.
Extension এ দিয়ে দেবেন দিদি। Extension এ দিয়ে দিন, হ্যাঁ।
I'm
Kindly, but
It was passed
matter, my
on
lord.
18th May 2026.
Give leave granted to file without
Well,
certificate.
it's kindly to mention one matter, my lord. CO 1066 of 2025, my lords. My lords had heard it on 19th of May, and my lords had directed that the matter shall be listed today. However, my lords, the matter has not been listed today. My lords, may kindly, much obliged. my lord.
Lordship, kindly keep the matter if possible
Keeping
tomorrow.
the matter, you please file it, give the number, then we shall see. Nothing keeping. Tomorrow is the only day. When can I keep now? Yes, call the list.
My lord, item 1, I am appearing on behalf of the petitioner. The impugned order, my lord, passed by the Debts Recovery Appellate Tribunal was to pre-deposit the 25% of the amount, my lord,
Why is it appearing as to be
for
mentioned?
non-prosecution, my lord, for non-prosecution. Well, my lord, the petitioner is willing to comply the order, impugned order, passed by the.
You have a letter or something of that sort, so that we can take it on
No,
record.
my lord.
You bring it. I'll
my lord.
pass the same order tomorrow.
My lord, kindly to take
Bring
it
that
tomorrow, my
letter.
lord, I will.
Not today. Next.
The instruction from the petitioner, my lord.
Yes, yes. That is the usual course which this court follows whenever a matter is withdrawn.
My lord, my lord, I shall.
Please bring something in writing.
Yes.
My lord, I am for the petition. This is for non-prosecution. My lord, your lordship will kindly keep the instruction record. My lord.
This is necessary. Keeping
Lordship,
something.
I understand.
is
I understand.
necessary. लिखें Mr. Singh, learned advocate, appear.
My lord, I think this is, there is a mistake in the date of the order.
Yes, 25.
20.
There are several same gentlemen who has typed it everywhere. The mistake is there. लिखें in. The matter
Order date, Lordship. 2025 mentioned, maybe.
same order করে দিন.
Lordship, I have already applied for the certified copy. Kindly direct to supply the same before the vacation. And
Lordship, direction I cannot give to the office. You
No,
manage it.
unless the
Same,
file is sent to the
Same order করে দিন. Yes. Next.
My lord, the council is appearing online, virtual, by the virtual mode.
Thank you, Lord. I'm appearing online.
Yes.
There is some difficulty with the network, but Milord, shown of unnecessary details, Milord, I was evicted under the Public Premises Act without giving me a hearing. The Honorable High Court in a writ petition had said that at least I should be given a hearing because the eviction notice mentioned that the land was needed for development purposes. The High Court said, all right, please kindly give him a hearing. The authority chose not to give me a hearing. There was no evidence adduced. There was no opportunity to allow me to cross the Port Authority. On 21st April, Milords, I was provided with a copy of the rejoinder. On 22nd April, an ex parte order, an ex parte order was passed. I challenged that before the learned city civil court. I sought for an interim injunction which was refused, and liberty was given to the port authorities to file their affidavit in opposition. I said that any time my godown would be put under padlock. The learned judge chose to disregard that. On 20th May, on 12th May, I again went before the learned judge and said, I have just been supplied with a copy of the affidavit in opposition. I need to file my reply. Kindly please give me an interim protection. The ground taken, Millard, was that there is an application for condonation of delay of 3 days that is pending. Plus the order is of 22nd April, the order of eviction. My delay, my period of limitation expired on 4th May. Your lordships know what was happening on 4th May. I filed on 7th May. On the ground that there was an application for condonation of delay, the learned judge said, no, this is a draconian legislation. Therefore, I need to give a further time. And I will post the matter on 20th May. On 12th May, this order was passed. On 12th May, the premises were put under padlock. May I kindly show, Millards?
What happened on 20th May?
What happened on 20th May, Millard? Yesterday, we sought a passover because yesterday we were before Millards. We sought a passover.
That is unfair. If you had your matter fixed over there, why would you not move it? Why would you take time over there merely because this is pending?
Millards, because may I kindly
your business was to get it heard over there. If it was heard, this would have lost its force. Unnecessarily, you cross that date by taking an adjournment, and you expect
no, Millards, I had only sought a passover. I had only, Millards, sort of kindly, Millards, allow me to place 4 pages. I will not trouble your lordship anything beyond that.
I'll send you
Millard,
back. Place your page.
But
there was a date yesterday.
This is put under padlock, Millard. And the next date given is 24th July.
I'll fix it. I will. When is the next date fixed? On 20th?
24th July, Millard.
I'll permit you to make an application for preponement of the hearing. Make an application for
I sort of
get it heard earlier. Because at this stage, even I will not be able to do it. It was there on 20th.
Until 2 p.m. I have no problem. Lordship, please, Lordship would kindly grant me protection till 24th. I will go before the learned court. I do not wish to agitate my appeal before your Lordship.
Padlock has already been put on your premises. Then any protection granting means I'll have to reverse the status quo. I'll have to grant status quo ante. That I will not do in under 227 jurisdiction.
Millards, my godown has been sealed because all my material is there.
Very well. If it has been sealed with all your materials there, they are not going to touch your materials without bringing an auction notice in play. They will have to auction it in accordance with the law. And if they do that, that will be done upon notice. So there is no case to panic. The city court and all the other courts will be having vacation only for a week, not more than that. Thereafter, you can have your chance. I will grant you liberty to move an application and get it preponed and heard.
Lordships, please. Lordships, please. I will not seek any reliefs further as to whatever your lordships, please. Lordships will kindly grant me an audience of 5 minutes. I seek nothing more from my lords. Lordship would kindly grant me an audience of 5 minutes. My lord, I need to show 4 pages. Thereafter, I will bow down to your lordship. Whatever your lordships decide. My lord would kindly see page 59. Page 59.
Page 59.
59, my lord. Para 6. It is clear that if any proceeding has been initiated by the estate officer shall conclude the proceeding after giving an opportunity of hearing. Now your lordships kindly see page 60, the very next page, your lordships kindly turn over.
Yes.
On 21st April, the record is that the rejoinder is filed by the port of the authorities that day. Your lordships have seen, and my lord would kindly see the 3rd paragraph. Matter is hereby reserved for final order. No hearing is given, your lordships have seen. Lordships would kindly turn over. This is the rejoinder. I am not going to facts, but your lordships would kindly take it from me that the rejoinder has absolutely different grounds from the eviction notice, without any evidence, without anything. And then the order at 79 millards is passed. ex
Very well.
parte.
Whatever on the basis of this, the order is still in force. I will not grant you status quo ante. I am still minded to send you back to the city court itself where your appeal is pending. All these points will be kept open for you to urge before the city civil court. The city civil court will take a decision in the matter. What will happen in a week? I'll ask it to prepone the hearing. You could have got the hearing done yesterday itself. Why did you
If your
seek a
lordships,
passover?
if your lordships kindly direct that, I will bow down. Even if your lordship direct preponement of hearing, I will
I'll
bow down.
exactly do that.
Because they are now demolishing the premises. They are not willing to sell on auction.
This revisional application is directed against. Do you know who appears for the port trust?
No, my lord.
Usually Mr. Nag appears. If you can bring him in his presence, I can pass an order so that preponement and all can be done. Sir Shubhankar Nag appears usually for this port.
I'll just try, my lord.
I'm passing it over if you can bring him.
Milord would kindly excuse me, the advocate on record, because I have a
Not a
medical
problem. Not a problem. I have disclosed whatever I'll pass. I'll pass the same order for preponement. If they are there, it will be easier for you also.
I apologize, Milord, that I will not be able to assist your lordship.
Not a problem. You were in trouble yesterday only, you told me. Not a problem.
I'm
Yes.
grateful.
Thank you. Next.
Item number 7, I'm for the petitioner.
9. My lord, I was waiting for 9.
Yes, wait. You will reach here. We'll reach according to the seriality. Yes.
Number 7, I am instructed to appear on behalf of the opposite party. Earlier, the copy, but I have not.
But they have refused to return back with the intimation, unclaimed, return to sender. But I shall have a copy and I'll come back on reopening day. I shall come back.
Now record for Mr. Such and Such appears and submits that
After 1 year, I am able to move this by the grace of God. Your matter is the partition suit. My clients are out of the suit property. Now they filed the partition suit and filed one application for injunction so that they cannot build and other side cannot make any construction in the open land. But that injunction, to dispose of that injunction, still now at interim, injunction made date 23rd
Junction
June.
application has not been disposed of.
Disposed of 5-6 years have
Objection and all has been completed.
it is completed. Series of adjournments.
This revisional application seeks expeditious disposal.
It's my application.
No, I mean,
Civil division. Civil division, Millet. This final hearing, Millet.
Yes, but she wanted it to be heard because she has said that there is pressing urgency in the matter. That is why
That would have waited till the reopening, I thought.
My lord, that
for 2 more weeks because a lot of matters will
Not
be held
that
up.
is valid.
it's a very short point, my lord, and has already
Short
been
point,
extended.
Mr. Rai will not allow it to be short. He will stretch it
But
like
my
a
lord has
chewing
been
gum and
already over
I'll
there.
be cursed by many, and including you and Mr. Rai. Because of this, since it is already there till the end of June, let us have it on the reopening day.
My lord, the only difficulty is that this has been continuing for the last 1 year.
Well, it fixes
That
it
is
on
the only difficulty. But it was fixed today after quite some time, my lord, and
I'm fixing it again on 9th.
Ninth,
I'll
Malad,
take
yes.
it as the upgraded motion itself. It will retain its position.
Very grateful, Millet.
Because nobody will have the patience to wait. Last time, everybody will want motions to.
Absolutely, Millet. I also feeling that, Millet.
my lord, the point was very short, but
It is not, Millet. It is not. Sorry, I do not agree with that.
Didi,
Short one is.
এটা 9 তারিখে রেখে দিন. List this matter under the same heading. at, no, on
for the petitioner lordship. For eviction lordship. Lordship, where lordship, order 39 rules, my order 39 rule 7 has been rejected, lordship. Suit was for eviction and recovery of khas position for eviction on the ground of reasonable requirement, lordship. We have filed written up the statement, lordship. Thereafter, the plaintiff filed order 39 rule 7, which has been allowed. We gave objection, lordship. And thereafter, the true picture was not in the report. As the true picture was not in the report, lordship, subsequently we have again filed order 39 rule 7, lordship, which has been rejected on the ground that delay for the just for delay we are filing that application, lordship. Only to bring the proper picture, the eviction has been done on the ground of reasonable requirement, lordship. Some other properties are also in the suit plot, lordship. That to bring that only, we have filed the order 39 rule 7, not to delay the suit.
no, but there is an earlier order of earlier report of commissioner, which according to the court is sufficient. Why this
Lordship,
second
we
application?
have raised objection. We given objection that commissioner report.
So let that be
Lordship,
decided first.
the commissioner, we have already filed the objection against the commissioner report also.
Even then,
So
madam.
room is there, lordship, that need to be bring into the record, lordship.
All right, serve and come, but no stay.
Yes, lordship. Grateful, lordship.
Petitioner is aggrieved.
Stay in the meantime, lordship.
No.
Grateful.
কি হচ্ছে?
My lord, I'm well.
Lord, this is that matter in which, my lord, a question.
Did we do it before the vacation? Unnecessarily, everybody will be stalled. It will take some time.
My lord, very short point, my lord.
Point is short, but he will also, I will have to, before the vacation, let us have small matters done. We'll keep it immediately after the vacation.
কি বলছো তাহলে? প্রসিডিংটা বন্ধ রাখবে তাহলে? The proceeding to stay.
Then, my lord, kindly.
Lord, then in that case, my lord, proceedings should be a state, so that, my lord, it may not be
When is the
rendered
next date?
infructuous.
When is the next date?
Because the matter is that is for revocation of the
Yes, but
certificate.
when is the next date? Next date is when?
First is second.
6th of June, my lord.
6th of June.
6th of June. 6th of June, 2000. 6th of June.
So I'll fix it on 9th, immediately after reopening. There will be no problem. On 6th,
But, my lord, the proceeding will
on
continue.
6th, it will not be disposed of. It cannot be disposed of in one
কি
on
জন্য
one
আছে?
day.
এই কি জন্য আছে?
For hearing of the full case.
Oh, for hearing of the main case. That is the reason, my lord. for hearing of the main case.
I will have to hear it. Very well, then I'm passing it over. Let me finish the short matters. I'll come back. Pass over. Because I will not stall the board in
Or
the
let
morning.
them give an undertaking that he will not proceed on that day.
I'll hear it out then.
Yes,
pass over
Lord
করে দিন। Pass over করে রাখ।
Lord,
ছোট ম্যাটার গুলো শেষ করে দিই একবার, কারণ এই the board will be stalled unnecessarily.
Lord, I cannot.
Before the
Disobey
vacation,
your lordship request, my lord. Frankly, I am submitting.
before the vacation, Mr.
No, no,
Banerjee,
that I know, my lord.
everybody
That I
knows.
know,
I was also on that side.
That I know. That is why I was hesitating.
Everybody will start cursing me before the vacation if I take. ঠিক আছে, এটাই দিয়ে ফোন করে বলেও দিই। 12টায় কেন? দুটোই তো। হ্যাঁ, দুটো তো না না দুটোই বলে ওদের বলেছেন নাকি? হ্যাঁ, দুটোই করে দেন যেটা আসতে পারে। নেক্সট।
Lordship, in this matter, I am for the opposite party. I am in Lordship seeking 2 days accommodation as the conducting advocate is seriously ill today due to heat waves. Sir. Kindly accommodate bread for today. Kindly
Today
fix
only,
it tomorrow.
not today.
If your lordship takes up tomorrow, my lord, it's some urgency. That's why it was mentioned and upgraded.
Tomorrow I'll take up, not a
Yes,
problem.
my lord.
Lordship. Tomorrow please do it.
Yes.
Not today.
Your lordship, I'm praying for a small passover, your lordship.
My lord, I am
Pass over again.
my
Small
on
passover, your
behalf of the learned advocate for the opposite parties, Mr. Ujjwal Trivedi. My lord, I have been asked to pray for my lord, not this week, my lord, after vacation.
Ma'am, tomorrow is, your lordship, tomorrow is the date before the competent authority for which we have filed the revision. I'm just asking for a small passover.
No, because last 2 occasions, I think in this matter, nobody appeared despite notice. So I had given it, I mean, made it clear in the order that will be taken
Yesterday
up.
also we have informed,
Giving a
today also
passover
we have
if you want,
informed.
please come back.
My lord, I am not in this matter, my lord.
Then I'll pass my orders because this can't be like this. He will proceed and then he will take time. Pass it over. Call kore deben next call. Next.
I'm for the petitioner, Milan.
So, but in this matter.
Milord, this is that matter where my cross-examination was closed, and on the next date, the advocate commissioner, when I paid for adjournment, the advocate commissioner has been appointed for taking my evidence, Milord. That
Why
matter.
advocate commissioner?
I don't have any grievance, lordship. The next date is fixed for DW in default argument.
Milord, what
If
has
we
happened?
agree to-
Milord, what has happened, Milord? I'll just come to the second part. On the last date before the learned trial court, Milord, what the kindly sees, the learned trial.
No, but he has recalled the order.
He has recalled the order, the second part of the order. Now I'm only on the first part of the order, the first order, first impugned order. Milord, where the evidence of the PW has been closed, Milord. I'm only on that part, Milord. Milord, here the learned trial court has fell into a jurisdictional error in closing my evidence. Why I say this, Milord? On this date was fixed for cross of PW1, Milord.
As last time, lordship.
The learned trial court had to proceed under the provisions of Order 17, Milord. If your lordship kindly takes up Order 17, Rule 3, it is in the second part or subpara A. If the parties are present, the court could proceed to decide the suit forthwith. If the parties are or any of them is absent, proceed under Rule 2, Milord. Now, under Rule 2, it has been stated that whereon any day to which the hearing of the suit is adjourned, the parties or any of them fail to appear, the court may proceed to dispose of the suit in one of the modes directed in that behalf by Order 9 or make such other order as it thinks fit, Milord. Now, the court did not proceed on the basis of Order 9, Milord. If the court would have set the suit ex parte, I would have had an opportunity to file a vacating application giving my reasons why I could not.
Since cross-examination was underway, let the cross-examination be completed and then defendant's witness.
My only prayer, Milord. My only prayer.
Lordship, difficulty is on 15th September, they prayed for time and it was fixed for the last
The
chance.
date is fixed on 10th of June. On 10th of June, his cross-examination will be concluded and then defendant's witness will continue thereafter. I'll go. So nobody will be.
I'm great.
Date, lordship.
I'm specifying on
Yes,
this.
Milord, we will be
Don't
present.
pray for time on
We
that.
won't, Milord.
This revisional application assails an order, this revisional application lays challenge Yes, before the
My lord,
vacation, why should we do it?
My lord, I'll request the lordship to keep it after the vacation.
Yes,
my lord,
even
if
I
not
was
that
thinking
way.
of that only.
There is
There is a date again in the learned trial court is what I was told.
on the 8th, my lords. On the day of reopening,
On the
8th of June.
Lord, in that case, if they ask for an adjournment, I'll not be opposing to that.
I'll just record that.
Whereas we pray for an accommodation, but your lordship will kindly just consider the prayer I made yesterday. But it's twice hearing as well, kindly.
Next week. ছেড়ে দিন আপগ্রেডেডই থাক না অসুবিধা নেই let it be in upgraded it will be better
I'm grateful.
you take long or you take long
Yes, no, your lordship, 15 minutes maximum.
They'll take half an hour, any date.
My lord, item 18 going on, my lord. My lord, is this item 18, my lord?
no not yet
I'm sorry, my lord.
Any time, if it can be fixed, we finish it off because written statement
let us
acceptance
come
is a
back on that
question.
day we shall see
Wait, I'm grateful.
18, my lord, Mr. Shibujyoti Chakraborty is appearing online on behalf of.
Yes, my lord, I am appearing on behalf of the Howrah Zilla Parishad, my lord. On the earlier occasion, I had prayed that since I would be outstation, my lord, so I am appearing virtually, my lord. I may kindly.
very well
But in this revisional application, now my lord, I am the defendant. Plaintiff filed a suit for declaration and injunction. In that suit, allegation is that unauthorized construction and my deed has been challenged. Now, my lord, when he filed the suit before that construction was completed, he filed a writ application before this court alleging, my lord, that my lord, there is some unauthorized construction. Ultimately, that writ petition has been dismissed by the coordinate bench. Although an appeal has been filed, but appeal has not yet been moved. Now, my lord, ultimately what happened, my lord, I applied for, in the premises, I applied for new electric connection. Now, learned trial judge initially asked me to submit all the documents that I have complied all the required formalities to the WBSDCL. I filed the cost which I have to bond. Now, my learned trial judge rejected in different aspect. If you actually see the impugned order, the learned trial judge rejected in different aspect. Now, your lordship knows better than us, my lord, that when we are making any construction, initially WBSDCL or the CSC used to give a meter for purpose of making construction. Now, my lord, construction has been completed, flats has been sold. Now, it is a duty of the developer to provide the other meters to all the persons. For that, I have to pay the cost, my lord, for installation of a my lord, transformer. That cost has also been deposited. Now, my lord, the learned trial judge rejected in different ground. If your lordship see once the electricity connection, I said that if section 43 provides, it is essential. If I reject this, if they succeed in the suit, everything will go. Now, kindly see, my lord, once the impugned order, 20th January 26.
Yes. The building does not have a sanction plan.
Absolutely, my lord. That if your lordship see once, my lord, the order of the coordinate bench, my sanction plan and everything, my lord, is with the at page 27.
Who is appearing for the municipality? Somebody was
Zilla
appearing.
Parishad. But your lordship will also find page 28, my lord. They challenge they said that I have not sanction plan. The ultimately, my lord, I produce all the sanction plan and High Court, my lord, the coordinate bench dismiss the writ petition. But kindly see page 28. The sanction plan is here, my lord. Your lordship will find, my lord, the date and if your lordship will kindly turn to the sanction plan, my lord. And my lord, the order, if your lordship see, my lord, page 28, the order of the coordinate bench, but have your lordship seen the sanction plan, my lord? Now see page 28. This writ petition has been filed by Nomita Nosh.
Yes, but this writ petition was disposed of or dismissed on the ground that it is inextricably linked with civil.
Absolutely, my lord, because no, regarding my sanction plan, my lord, this has been discussed, my lord. Kindly see once. But page 31.
Page 31.
Page 31, my lord, second paragraph, third paragraph. It is pointed out that the writ petitioner does not specify the exact nature of the alleged unauthorized construction. Only vague allegations have been made without indicating in what manner the building is unauthorized. It is emphasis that the building has been constructed in accordance with the
Zilla Parishad stand on this?
We have the sanction plan. Kindly see.
No, sanction plan is there, but whether the construction is in accordance with the sanction plan.
Absolutely,
My lord, in this regard, my lord, on behalf of the Howrah Zilla Parishad, my lord, I have already requested for instructions, my lord. Now I am yet to receive the instruction. We'll file the report, my lord. Kindly a week's time may be given, my lord, for filing the report, my lord.
Appear after because this since it is before a judicial authority, you cannot simply say that he is absolutely wrong. He cannot direct electricity connection to be supplied to an unauthorized construction.
If your lordship see once, but the reason for not.
First part, I agree. Status quo cannot be a reason
No,
for
kindly
not
see.
of
No.
electricity, but
Well, it is not the observation with due respect observation of the trial judge. It is unauthorized construction. Kindly see.
No, he says without furnishing proper project completion certificate. He wanted to aim at that only.
But I have the your lordship. I have the judgment man also. Number I have the sanction plan. It is their specific case
No,
now.
Sanction plan you may have, but in terms of the sanctioned plan, whether the construction is there or not is a question of fact. You may have a plan. Plan may be of 3 stories. You have a 6 stories building. You can't say that it is in terms of the plan.
What is their case? Kindly see once. Kindly see once. What is their case? Their case is that I don't have the sanction. May I just show? But had it been the case, my lord, I have the sanction plan up to G+2. I have made construction up to G+6.
What is their case? You don't have a plan.
My lord?
What is their case? You don't have a plan.
Their case is that I don't have. Kindly see, my lord, page 28.
No, before the trial court,
before
this is writ court.
Before the writ court, their case is
trial court.
Yes, trial court. Kindly see once.
The petitioner did not have any sanction plan. But evidently, my lord, the paragraph, my lord, says, my lord, an unauthorized construction has been made. The matter has been it's pending before the Zilla Parishad for regularization of that unauthorized.
No, my lord, that is not the case.
Yes, that paragraph, page 32, that is not being placed.
Kindly see once.
Last part, one paragraph, page 32.
But for one Thakurgarh, my lord, one estimate plan has been made. That Thakurgarh, I am not asking for any, my lord,
if the electricity connection is in respect of the authorized
portion, yes,
authorized portion, then how can that be injuncted?
Now, my lord, let's kindly come to page 25.
Page 25.
Order dated 9th October 2023.
9th October 2023.
Next page ordered. The defendant number 1 to 6 and on any other person related with them in any manner is hereby restrained from doing any activity which would create disturbance and annoyance in the peaceful possession of the suit schedule B property as possessed by the plaintiff. And
I am not disturbing because he has a only tea shop room in the ground floor.
I can understand his anxiety. I also restrained from causing any obstruction and hindrance into the running of business as well as the ingress and egress of the children.
Absolutely not.
The director to maintain a state of affairs status quo of the shoot property as mentioned in the schedule B.
That will not prevent.
Now, this order, they have not preferred any
Not
application.
required.
Not required.
Status quo will not prevent in the prevent the electricity authorities or the petitioner to take electricity connection.
I'm not on that.
My lord, kindly direct to decide the matter afresh.
You can use affidavit, my lord. No, not. My lord, this order was prevailing. Construction was not there. My lord, they made
The construction completed long ago.
The trial court must come to the conclusion as to whether the electricity connection is that has been sought for is in respect of the portion of the premises which is authorized or which is
absolutely a portion.
Whether the construction in violation
entirety of the construction cannot be unauthorized because there is a plan. Because some portion must be in construction in consonance with the plan.
But kindly see the writ petition. Their case is that there is no sanction plan. This is the writ petition. He cannot go beyond that. And it is not their case in this is the writ petition. And different lawyer and not only that.
When there is an order of status quo, whether any construction can be made or not.
Completed long ago.
That question is to be decided by the trial court. We are only on the question of whether electricity supply can be effected at the premises or not. Insofar as the electricity supply is concerned, status quo order is neither here nor there for that. Nothing is going to change, neither the nature nor the character nor possession. Electricity, it's settled, well settled.
Electricity can be given.
So let him give that.
Can be given in respect of the building which was constructed.
In respect of a building or in respect of a portion. So we have there is a thin distinction, but there is a distinction. That distinction you cannot over.
Not in violation of the court's order.
If it was in violation of the court's
order,
he
did not file order of rule 2A.
The portion which is in violation of the court's order.
Entirety. I have
entirety of it can't be. If it is in terms of a sanction plan, the entire building has come up after status quo.
He has not filed any order 38 rule 2A. Kindly
9th October the order was passed.
Take your steps.
I have, my lord, that photograph.
He has produced all this.
I will not see that photographs in civil divisional jurisdiction.
The nature of the construction as on 9th October.
Sir, that has to also be decided by the learned trial court in appropriate proceedings. If there was a violation of the order of injunction, nothing prevents you to take appropriate proceedings.
But since 23 he has not filed order 38 rule 2A.
For that, you cannot ask somebody to be shut down because he has violated the order of injunction. You cannot ask somebody's water supply to be disconnected. There are specific remedies for specific wrongs. If he has committed a wrong, you have a remedy, go there. But so far as this is concerned, that cannot be a reason to stop. You are not allowing the court to complete the sentence. You cannot go on arguing with me like this. You make your submissions, I'll pass my orders. No, you please complete yourself. Complete. I'm waiting for you to complete. This is a bad habit. Speaking every time whenever I speak, you please complete yourself, then we shall see whatever has to be done. Conclude. We are wasting time.
My responsible submission to your lordship, my lord. So far, my lord, the building is concerned, my lord, it would have been appreciated, my lord, had there been no electric connection. My lord, electric connection is there, my lord. They are using the meter installed by the WSCTC, that is there, my lord. They are using, my lord, and enjoying electricity out of that.
Very well.
And in reply to submission, 2023 order, he is saying I have violated. Till today, no application under order 13 rule 2A, and construction has been completed in my lord 2021. Transfer has been made 2022. Everything has been placed before the coordinate bench in the trial court. Kindly see page 19, his area. His area is only 99 square feet, a tea shop room.
Why did the court not ask for a report from the Zilla Parishad? It could have asked for a report to get it clarity.
That could have been done.
Then why rejecting at the threshold? He has not decided it. This revisional application.
affidavit service filed in Capricorn.
Affidavit of service filed in court.
But I have instruction to appear
Yes,
for the
yes.
opposite.
ওই ওনারটা কল করে দিন না একটু। পাস ওভার ছিল 10:30।
Night.
Yes. Yes, he's there.
My lord.
Yes, there is an order passed by the estate officer, your,
Yes, yes.
that is pending in appeal before the city court.
Lordship,
It is delayed by 3 days.
Lordship,
City court is in consideration of the stay application as well as the
Lordship.
dependency application. The contention of the petitioner is that in the meantime, you have put padlocks, they are out, you have started demolition.
No, my lord, I tell your lordship, the instruction which I have received, that my lord, as there was no stay order, position was taken and the position was also given to third party. So a third party right has also been created in respect of the property. So my lord, in such circumstances, my lord, passing an interim order, if lordship wants, I can give affidavit to that effect to your lordship.
No, I will not then pass an interim order. I'll relegate it to the city court, but I will give them an opportunity to get the hearing preponed.
Yes, yes.
Hearing
That I am agreeable. That I am agreeable.
So I'll record that so that
Lord.
both parties can go and get it preponed and heard.
Lordship,
They cannot
that's better because a third party right has been created. So that is why.
stripped of their rights completely.
My lord.
Having their appeal pending, it makes no sense.
No,
Which
my lord,
was-
I tell you, lordship, my instruction is there was no section 5 application. There was a delay. So the appeal on that day was not on board itself. So if there is delay and if there is no condemnation of
Now, since an appeal is there and
now it is there.
They have come up here.
Lordship.
Please ensure that it is preponed and heard,
Lordship,
because
lordship,
there
I am
will be a
agreeable.
week's vacation. This court will be off for 2 weeks. And it will not be proper for this court now to intervene at this stage, keeping the stay and everything pending over there. So that should be preponed.
Lordship.
May I seek an indulgence, my lord? If there could be some kind of protection given till the disposal of the appeal, my lord.
Mr. Nag, after third party interest creation, he has
It's
also
created
washed his
all.
hands off.
My lord, but that was done during the pendency of the appeal, my
There
lord.
was no stay.
My lord, because there was an order passed, and thereafter we had immediately.
The problem is, as he points out, when the appeal was initially filed, it was filed without any section 5. Therefore,
My lord,
appeal was
because-
stillborn. Now, the section 5 appears to have been filed only on 12th of May 2026.
My lord.
And when was your third party interest created?
No, when?
My lord, it has been created then earlier.
14th. On 14th.
And 20th was the date. So before
My-
the hearing, it has been done.
My lord, which is what we were trying to agitate before, my lord, my lord. Even
This revisional application has also been filed only on 13th.
my lord, this revisional application was filed. I had sought leave to file without certified copy of the order, which my lord had granted. However, my lord, thereafter, because of certain delays, the
All
matter
these
was.
things, there is no stay. At this stage, putting the clock back will be difficult and it will
My lord,
not
just
be proper.
some protection till
We don't know who the parties are.
they would know, my lord. They are appear.
That
They are not before us. We will not be able to injunct them because passing an order now will be injuncting third parties from creating
My lord, it was.
whatever is there. It's list pendants. If it is there, ultimately you win your appeal, you will get all your things back. And they will be
I
responsible.
tell you, lordship, on that score, my lord, that this was used as godown. My lord, the goods are safe with us. My lord, we have also initiated proceeding under
But that
section
is-
6.
That is what.
Also
they-
under section 6 for disposal, where he has the right to agitate his grievance.
My lord, that is what they had said when we had filed the appeal initially, that nothing is going to be done.
Yes.
First of all, my lord,
Also, my lord, an adjacent warehouse, my
Achha,
lord,
I
I
have to
require
make
the copy.
submission. I have to make submission.
I need to have.
First of all, I'm grateful to your lordship that your lordship, upon my repeated mentioning at odd timings, your lordship has kept the matter. Lordship, I am stands in a 1 degree better, in a better footing than what my learned friend was. Here, there is a stay order from the eviction order passed by the estate office. Sorry. Sorry. Here, there is a stay order I obtained against the eviction order of estate officer. We served the copy upon them 12 days thereafter. After knowing that the stay order is there, they come and take physical possession, put the padlock. It's a running business. I am not able to operate. I am being dispossessed. Judicial order has been violated. I made an application in the nature of 151 for restoring back the possession and to deseal the property. And lordship will see the impugned order, unusual impugned order says, even though there is a stay order, full stop. However, there is no status quo injunction, so I cannot grant you any further order. This is, I don't understand this.
Why this?
My lord, I don't know, my lord.
Lordship will
I
see order.
my lord, 2-3 things, my lord. I need to have the copy. Number one. Number
Give a copy, come tomorrow.
Tomorrow, so I will give the copy, but fact is that, your lordship, when
Fact
we,
is nothing. Give a copy if he's there. I cannot hear you and pass an order today. Give a copy.
lordship, this has to be restored back.
No
Actually, serving.
restoration here. In any case, it has to go back there. I'm making it clear. No restoration
Your
from
lordship,
here.
I
But
am
this has to be
dispossessed.
set aside if I am satisfied.
Your lordship will set aside that order. I am praying
No,
for
not
final order.
before hearing him.
No, obviously, I will serve a copy.
Give him.
Your lordship will kindly keep this matter
I have
sometime.
received the copy, my lord. I will
I've
come back
kept
to
it. It will be there. What happened?
I don't know. He has some confusion.
Not today. लिखे नहीं একটা order record করে নিন. Order record করে নিন.
No, copy no.
Mr. Nag, learned advocate. সবই ভুল হচ্ছে, কি হচ্ছে সব ম্যাটার গুলো, কারণ আর এর আগেও তো একটা ভুল হয়েছিল, আজকেই তো হলো। তাহলে তাহলে সবই ভুল হচ্ছে কেন? এরকম এত ভুল হচ্ছে কেন আমাদের? এত ভুল হলে তো ঠিক না। ও তাহলে ঠিক আছে, তাহলে ঠিক আছে। কি আবার কেউ নেই?
Well, this is my.
Yes.
Well, in this application, I am seeking a specific direction to complete the examinations, my lord. Kindly seize, my lord, page number 75. Order number 9, dated 2nd of December 2024. There was a direction to fix the cross-examination of PW1, my lord. My lord, thereafter, several dates. Page number 75. Order number 9, dated 2nd of December 2024. Matter was fixed for further cross-examination of PW1. Thereafter, my lord, several dates till, my lord, page number 78. Having no other alternative, my lord, they have filed revisional application before this honorable court to expedite the matter. There was a direction to expedite the matter. Page number, my lord, 81. Order dated, my lord, 19th of September 2025, passed by Honorable Justice Hirmay Bhattacharya, my lord, but they have not complied with. Thereafter, my lord, they sought for time, and my lord, the last annexes, my lord, certified copy. Kindly seize, my lord, order dated 21st of November 2025. They filed Hajira, but at the time of examination, my lord, they didn't turn up, my lord. Page number, my lord, next page, order dated 2nd of April 2026. 5 dates are passed, my lord, but they didn't turn up. Today, my lord, I am seeking a specific direction, at least 3 to 4 months. With this 3 to 4 months, my lord, they need to complete the examination process.
This revisional
Item number 22, I'm appearing for the petitioner. My lord, in the morning, Mr. Obrutosh Mujumdar had mentioned the matter. My lord, any date on reopening, my lord? Any date on reopening, my lord? We shall come back, my lord.
Very well. It will appear in the same heading after.
And my lord, there is a date on 2nd June before the trial court. May I be permitted to seek an adjournment on that date?
Then I would have to hear it. You seek an adjournment, whatever happens will happen.
I'll come back, my lord.
দুটোই আছে তো নাকি লিস্ট তো বেরোয়নি এখন না বেরিয়ে গেছে বেরিয়ে তো দুটোই আছে না এই তো ওরা চলে এসেছে হ্যাঁ এটাও তো ইয়ে করবো Mr. Bose and Mr. Ganeriwala, please come at 2. I have kept the other matter also at 2, which I passed yesterday. I'll have to release it after recalling the order.
Release it?
Yes.
Why?
It should have been brought to my notice.
That's why I understand.
I had represented one of the directors of this company in an absolutely unconnected matter.
Unconnected then?
Even then. At this stage, we can't.
We do not have any issues,
No,
Lordship.
but my conscience should be clear. At the time of finalization of the order, I went through because it's very difficult in a thick bunch to
correct.
Selective page, and then by Guru's grace, I got it.
A Lordship appeared for the director. The director really has. Of course, I leave it to your Lordship, my lord.
It won't be proper. Won't be proper. Won't be proper. I have directed it to appear in the list as to be mentioned. I'll recall because I have not signed it, so I can recall it. I'll recall it and it will be released. So this will also be released at 2 p.m. You come, I'll release both of them. Please be here at 2 p.m. So it's not there. The list shows
not
2
there,
p.m. We'll come back. File also has to come. The order has to be there.
Very happy.
I was in any event more happy with the Lordship's order, my lord, to be very honest. It was
That kindly, my lord, write that line also before releasing it.
grateful, my lord.
I appear for the opposite party, my lord, being led by Mr. Barrett.
Yes, sir. দিদি এটা একটু কাটুন না
করবেন স্যার
ইনভিটেশন চাই যেটা বড় ম্যাটার গুলো আপনি ওখান থেকেই কেটে দেবেন এই প্রত্যেকদিন ডাকাটা অসুবিধা হয় দেওয়ার আগে আপনি কেটে দেবেন প্রত্যেকদিন উঠে এসে কাটতে হয় এইসব রয়ে গেছে দেখুন কার রয়ে গেছে এখানে অ্যাফিডেভিট অফ সার্ভিস টার্ভিস রয়ে গেছে এগুলো নেয়ার সময় নিয়ে নেবেন Yes. Yes, sir.
My lord has the kindly see my lord order my lord of 14th May 2026. Lord, I have been given my lord visitation right. Kindly see me led by Mr.
It's a question of interim visitation right. Now, I'm not. My client wanted a 2 weeks visitation, not personal visitation, and the child to stay with me for a period of 2 weeks. At the time of hearing, it was restricted to 1 week because the mother would take him for a vacation. Now, please. Now, in the meantime, there are guidelines framed by this Honorable Court pursuant to orders, judicial orders. But I wanted implementation of those guidelines because those guidelines have an avowed object to subserve. Now, I'm not in the objection filed to this application by my client. Principally, the custodial parent agrees. But there is a disagreement with regard to the mode of transition. How the child has to be handed over.
Now, please come to pages 89, 91, and 92. Now, these will be the guiding factors for the purpose of this adjudication.
Page 89.
89.
Page 89.
Please come to clause 4. If any session of visitation is wanted to be avoided by any party on the ground of any unavoidable circumstances or discomfort of the child, that session can be rescheduled at the agreement of both the parties. However, if the court chooses to appoint any special officer to oversee the interim visitation procedure, the parties shall immediately inform the special officer of the reason of the such variation or alteration of the schedule, and the special officer may personally see or talk to the child, and upon satisfaction may allow the parties to reschedule the session to any date of their convenience. If the court finds it necessary, the court may at any stage of the proceedings appoint any special officer to oversee entire visitation process. The special officer shall record his observations after every visitation and shall submit a report to that effect before the court at regular intervals as the court may deem fit. Now, please come to pages 91 and 92. Communications. I skip over 91. Please come to 92.
Yes.
Additional visitation. The non-custodial parent shall be entitled to exercise other reasonable visitation in the locale of the child's primary residence or at the other places like club, place of worship, shop, ground, mall. Not the court has allowed it a mall for a period of 1 hour, and in presence of the police if required. Upon reasonable notice, subject to a minimum of 12 hours notice to the custodial parent whenever there may be need where the non-custodial parent may wish and desire that the child should be present on certain occasions such as so and so. In such circumstances, the custodial parent shall allow access to the child immediately. Now, these are the basic guidelines, but the objects may appear from pages 84 and 88. Please come to page 84.
Page 84.
Now, the second paragraph on that page, these guidelines shall apply to both interim and final child visitation rights. Visitation shall mean and include regular visitations, weekend visitations, festivals, pujas, religious functions, birthday, anniversary celebrations, marriage in the family, and medical emergencies of non-custodial parent. The courts will have the powers to appoint amicus curiae or the child welfare expert and special officers who will exercise powers under sections 12 of the Family Courts Act or so CPC, and emphasis may be given at any interim custody stage. Skip over the next paragraph. The basic principles of the courts are to ensure that the children get spend equal or substantial and significant time to be showered with love and affection from both the parents, irrespective of parents' conflict. Please skip another paragraph. If the parties cannot agree on visitation, their first alternative is to mediate the conflict. Visitation is for the primary benefit of the child. Visitation should not be viewed as a privilege to be exercised at the whim of either parent, but as a responsibility that should be fulfilled as a necessary cause. The custodial parent is expected to provide access to each child at unscheduled times if requested, and if to do so would not unreasonably disrupt prior planned activities of the child or the custodial parent. Now, these are the objectives. Now, Lord, please see my prayer, which was before the court, trial court, at page 166. Granting exclusive physical visitation or temporary custody of the minor child to the petitioner father and the paternal grandparents for 2 weekends of the summer vacation 26 at the home of the petitioner or father's maternal uncle at New Alipur. Directions be passed appointing a neutral child counselor or child psychologist or advocate, including a professional from the panel of the West Bengal Commission for Protection of Child Rights, having its office at so and so, to facilitate the handover and ensure the respondent mother does not interfere with the exclusive access if granted by this learned court. Now, to this, the objection is, please come to pages 185 and 187.
Yes.
Paragraph 10 at 185. Please see the third sentence. It is submitted and reiterated that welfare of the minor child should be subsumed or stand secondary in light of the Calcutta High Court's child access and custody guidelines along with the parenting plan. The apex court in a multiple decisions upheld the paramount welfare and well-being of a minor child without any straitjacket application of the law or a schedule. As a matter of protecting the interests of the minor, it is submitted that the petitioner is attempting to use the minor child as a tool and weapon in the present proceedings. No, it's a proceeding for custody. But I don't know that. Please come to 187 now. Onward, Lordship, skip over to 188 straightway. But the last sentence of the paragraph 17 just above paragraph 11 just above paragraph 12. But the last 4 lines of the first paragraph of that page, the petitioner has been, has your Lordship got that? The petitioner has been given access to the minor child by way of video conferencing calls that happen on a regular basis without any fail, along with physical visitations as may be granted by this learned court in due compliance with the orders. It is denied that there has been any damage to the psyche of the minor child as alleged or at all. Please see the last 4 lines of that page. It is submitted that the minor child is being forced by the petitioner to react and spend time in a way that utilizes time with maximization, which cannot be the case of any individual, let alone the young minor child presently involved. It is further denied that the current arrangement in place for handover of the child is in any way whatsoever proven to be ineffective as alleged or at all. So, instead of a hourly visitation at a mall, I wanted the child to stay with me over 2 weekends. Now, please come to page 190, not the other admission of the respondent, of the opposite party, 190. Not the 4th line from the top of that page. I have never obstructed the child from knowing or interacting with members of the paternal family or the world outside in accordance with the directions of this learned court. It is denied that the alleged neutral child counselor or child psychologist or advocate should be involved, since the damage that has been caused by the petitioner and his parents cannot be undone. Therefore, the petitioner's plea for appointment of a neutral child counselor or child psychologist or advocate for facilitating future interactions with the child ought to be nipped in the bud, as the same would only aggravate and compound the existing mental and emotional distress suffered by the child to the detriment of his welfare and well-being. Now, this is in contradiction to the laid down guidelines of this honorable court. Now, now the other relevant provision is the statement is at 192. Now, the 4th line from the top of that page. It is specifically stated and submitted that, keeping in view the aforesaid circumstances and considering the utmost well-being of the minor child, the father should not be permitted for overnight access to the minor child, as the father has not minimum rapport with the minor child to spend even for an hour with the minor child. Now, I'm not keeping aside all things, but the object of the guidelines is to build up this bond, if there is a non-existent bond. Now, he is a 7-year-old son. Now, principally the grounds for the application had been accepted by the learned trial court. Please come to the order impugned. Now, I skip over the first 2 pages. Please come to the last paragraph of the 2nd page of the order. From the records, it appears, has your Lordship got that? From the records, it appears that previous visitations have not yielded the desired level of independent and meaningful interaction between the father and the minor child. At the same time, the court also notices that the mother is admittedly traveling with the minor child from 17th May to 31st May, and therefore the present prayer of the petitioner has been confined to the 3rd weekend of the summer vacation. The limited nature of the present prayer appears reasonable and deserving of consideration. This court is further of the considered view that mere reluctance or visible resistance shown by a minor child during transition cannot automatically lead to complete denial of access to the non-custodial parent, courts exercising parents patriae jurisdiction are duty bound to strike a balance between the emotional comfort of the child and preservation of the parent-child bond. That's in alignment with the guidelines. In this context, reference may profitably be made to the decision in so and so, wherein the Honorable Calcutta High Court emphasized that orders relating to custody and access passed by a competent court cannot be rendered ineffective by deliberate non-cooperation or passive resistance of the custodial parent. The Honorable Court observed that where the custodial parent adopts conduct defeating the implementation of visitation orders, the court is not powerless and may issue necessary directions to secure compliance in aid of the welfare of the child. The ratio of the said judgment clearly lays down that the custodial parent bears a positive obligation not merely to formally produce the child, but also to facilitate meaningful compliance with visitation orders. Passive obstruction, emotional conditioning, or conduct frustrating the spirit of the order may invite adverse consequences. Thus far, all observation in favor are in favor of the applicant before the trial court. This court is also mindful of the evolving jurisprudence surrounding parental alienation, emotional dependency, and psychological vulnerability of children caught in high conflict custody disputes. Courts across jurisdictions have repeatedly observed that where allegations of emotional manipulation, trauma, fear conditioning, or parental alienation surface, assistance of neutral child counselors, psychologists, or child welfare professionals becomes necessary to preserve the emotional welfare of the child and to facilitate healthy transition between parents. Where a child repeatedly demonstrates unexplained hostility, indifference, or emotional withdrawal towards a non-custodial parent, despite absence of any prima facie allegation of abuse or danger, the court may legitimately examine whether such behavior emanates from interparental conflict, emotional dependency, or subconscious influence. In such circumstances, therapeutic intervention through neutral professionals becomes not only desirable but necessary. Accordingly, this court finds that a carefully structured visitation arrangement deserves to be put in place at this stage. Prayer A is allowed in terms of the following order. Prayer A was the weekend custody, third weekend, not for weekend. The father is allowed exclusive physical visitation of the minor child on 6th and 7th June 26 from 5 to 7 p.m. at South City Mall. I skip over, this was earlier given also. Please come to direction number 3. On the next page, during the aforesaid visitation hours, the father and the paternal grandparents shall enjoy exclusive interaction with the minor child without unnecessary physical proximity or interference from the mother. Please come to paragraph 9. The court further observes that if the minor child continues to exhibit persistent hostility, indifference, or emotional resistance towards the non-custodial parent despite structured visitation and absence of any substantiated threat perception, this court shall have no other option but to consider prayer B. That's not the engagement of a trained counselor for the purpose of this transition. 10. Accordingly, both parties are directed to remain present before this court on the next date. Paragraph 11 is shocking. The officer in charge of the concerned police station shall render necessary assistance if any disturbance or obstruction is caused during implementation of the present order. What the Honorable High Court laid down as guidelines not to be done through trained counselors, intervention of police for the purpose of this interaction, but this completely frustrates, and this creates a trauma rather than this enhances something, inputs something which is not desired. Now, for the time being, I had prayed for a weekend, the third weekend to be spent with the child. I have come with an instruction, Mr. Banerjee to consider. From 12 o'clock, she objects to the overnight stay of the child. From 12 o'clock in the daytime to 6 o'clock in the evening. And I return the child back. The distance is Kalighat to New Alipur.
Mr. Banerjee, why don't you consider this appears to be not very unreasonable, subject to whatever you say?
My lord, fortunately, my lord, there's a history, my lord, behind this, where, my lord, otherwise, my lord, we would have had, my lord, absolutely, my lord, no objection. But
shared parentage is something which...
No, my lord, here, my lord, is slightly different. My lord, 19th April 2019, my lord, the child is born. My lord, there has been no cohabitation. The father, my lord, was not there, my lord, during, and that's one of the complaints, during pregnancy as well as during childbirth. There's absolutely no bonding between, my lord, the father and my lord, the son, who's now 7 years old. And I'll show my lord their own affidavit, which has not been my lord disclosed with this. My lord, there's absolutely no bonding. First time my lord, they approached court, my lord, was in 2024. And the order, my lord, is of June 2024. Where my lord, video conferencing was given, my lord, every other Sunday. No appeal from that order. Again, my lord, December 2025, they filed another application. And I'll show that order also. There also, my lord, they said, and but then again, my lord, nothing, my lord, given, and no, my lord, appeal from that also. And what is the difficulty, my lord? Even the guidelines say, my lord, the child's welfare, my lord, is the most important. Most important. Now, my lord, the child, kindly, my lord, look at this affidavit, his own affidavit. I don't know whether, my lord, my learned friend has seen a copy of this affidavit. Kindly, my lord, has a look at this affidavit. It's the father's own affidavit. This is what happened, my lord, on 12th June. 12th April, my lord, when the father met, my lord, the son. Even the grandparents have never, my lord, seen the my lord, the son, my lord, grandson, my lord, for the first time in 2025. There's no cohabitation. No cohabitation. Look, even his own petition, I'll show. He says from 2022, he's been completely, my lord, custody of, my lord, the mother. So I'm, my lord, at least, my lord, overnight, my lord, he's not pressing. That's, my lord, something, my lord, which is important. But, my lord, here, my lord, they've given, my lord, the court has considered it, given, my lord, 2 hours, and also said that, my lord, come back on the 10th of June. I don't know, my lord, it's a very reason, my lord, order, my lord, with regard to, my lord, the visitation rights. And 6th and 7th.
For the time, if Mr.
My lord, kindly look at, my lord, this affidavit. The father, my lord, is unable to keep the child.
Where is that?
My lord, kindly look at, my lord, page 2. The order, my lord, is narrated in paragraph 5. Pursuant to the order, on 12th April, my parents reached the said venue, time to meet my son physically and celebrate his birthday with him. Message them, I respond around 5:30 p.m. We'll waiting outside the time zone. Order had said time zone. Then, my lord, paragraph 6 onwards. My minor son Virat was walking, holding the hand of the respondent mother, looking down, seeing him, my parents and I approached him, wished him happy birthday, sang the happy birthday song, and attempted to interact with him in a warm and affectionate manner. However, immediately avoid interaction, closed his eyes immediately, covered his ears with his hands to avoid listening to the birthday wishes, and started hiding behind the respondent mother. Throughout the visitation, minor child remained continuously in close physical proximity to the respondent mother, expressed that he wanted to go home and did not wish to remain at the venue. Various points during visitation, my son Virat sat on the floor, holding onto the respondent mother's leg, sat on her lap, and avoided eye contact, interacting with me and parental grandparents. That repeated attempts were made by me and the parental grandparents. Engaged the minor child through conversation, affectionate interaction, gifts, and simple activities. However, the minor child remained withdrawn and resistant to interaction. My parents tried multiple times to approach my minor son, wish him and interact in affection man, but he kept trying to move away, hide and cling to respondent mother. He repeatedly pushed the respondent mother away from our location in a direction leading further away. All through the interaction, the minor child kept his eyes closed, avoiding eye contact with me and my parents, remained stuck to the respondent mother. Me and my parents also sat down where he was sitting on the floor outside time zone to interact with him. However, he continued to hold on to the respondent mother's legs, did not respond to us. Each time she would say, Ki chai, what do you want? Or Kole Ashbe, want to carry me to the minor child. That during the course of the visitation, no meaningful transition could take place.
Yes,
Respondent
I've gone through it.
limited attempts to encourage the minor child to
I've
interact.
seen it, Mr. Benj.
So, Lord, one has to, Lord, take into account, Lord, we don't, Lord, we are only here, Lord, try and, Lord, assist, Lord, the court and, Lord, the parties. And, Lord, page, Lord, the photographs are there. Lord, I'm worried, Lord, what effect it will have on the child. And this is not, Lord, and even, Lord, in fact, if, Lord, my learned friend is showing the guidelines, kindly, Lord, look at, Lord, page 85 of that same guideline. The guideline also, Lord, recognizes, Lord, page 85, reintroduction of the absent parent. The guidelines assume that each parent has been in a continuous presence in the children's life. In the event that a parent has been limited or no contact with his or her children and wishes to be reintroduced in the children's life, it is up to the parents to agree on the means by which this is to be accomplished. If the parents are unable to agree, First alternative shall be to mediate the conflict. If mediation is successful, it shall be the responsibility of court to adopt a schedule to ease the reintroduction. And my lord, kindly look at my lord, his own averment, my lord, in the petition. Kindly, my lord, come to the civil division petition here. Because this is only an interim order, my lord. As interim order, we are told to come back on the 10th of June, 6th and 7th, my lord, rights have been given.
Mr. Majumdar, if this is only an interim arrangement, of course, as it is, and the court is already in the season of the matter, the court will hear again. Since it's only a phase of transition, he's only seeing as to how the child acclimatizes itself with the father's company.
Now,
once the child gets used to it, we can think of increasing the time.
Absolutely.
But the object is not to propagate this alienation.
No, that is why it has to be.
That's it. So the effort is towards a bond being created.
Yes, right.
That's the sole objective.
That is why instead of having a long custody for a long period, he has kept it short and he has kept it. He has started
At the mall, this does not work out. This does not work out at the mall, more so not when the police intervention is desired.
No, police intervention.
Police intervention only. It's only saying, if there is any
the mother comes with
cut that off.
the mother. There are records to show the mother comes with her friend photographer to click these photographs. No, this is not desired.
These things will.
May I do this?
No.
May I pray for this? Kalighat to New Alipur is not a very long distance. It's a very short distance.
Won't be able to keep the child. I'm otherwise, my lord, I would not have stood in the way, my lord. If it was a normal, my lord, situation, I've taken instruction. I've had, my lord,
Lordship has been pleased to find that there is an intervention of a trained counselor or even from the child welfare commissioner for the purpose of implementing this process or transitional access. This can be done. An independent person will be there. If she or he finds that this is not working out, we can render all assistance to bring the child back to the mother. She's also working lady.
Let him, my lord, keep for 2 hours first. Let him come back and then say, my lord, yes, I've kept him for 2 hours. I've been able to handle the child.
In the presence of the representative of the child welfare commissioner, Lordship may permit the child to be kept for 3 hours in the residence, not the accommodation that I have mentioned.
Residence, my lord, my lord.
Why can
because the bonding is not there.
Let him not.
But he himself, my lord, I'm only showing, my lord,
he not foreclose this.
You should have disclosed this.
The idea is not to perpetuate this debonding.
Before the
then Mr. Majumdar, we can have this as a shock. If we give it to the child, it may be counterproductive also.
That's why not a 10%.
That is why in the beginning, because it's not unusual. Having visitations in malls is not unusual. We have seen such orders. Even
it is there, but
have upheld such orders.
It is there, but it really does not work out. Does not work out.
Situations, it may not. In certain situation, it works well because of the surroundings. Now, in this situation, this is just the beginning. It's not something which has attained permanence and it is going to stay forever. And the court has fixed it on 10th of June. We'll slash out that part where the police officer has been directed to render assistance. The police has no business here. He'll not be there. That order is that part of the order I'm going to set aside. We can increase the time. Instead of 2 hours, we can make it 3 hours at the mall itself. That can be done.
Please say only one document, page 170. The court is insisting on mall, but this probably does not work out in presence of too many persons. Nobody knows how it works out.
No, it should work out more when there's one distraction for a child who's 7 years old. There also, you can't handle a child.
No, it's not that. I have got photographs to show. It's incorrect that I have not visited the child ever. Since up to 2021, there was interaction. Please come to 171.
171.
Yes.
Sorry, before I was showing his averment, but I'll not wait till.
Ordered. The father, please see the third sentence of the third line of the ordering portion.
Yes.
The father shall meet the minor child on 28 December 25 from 11 to 3 p.m. at South City Mall. The mother shall hand over the child to the father exactly at 11 on 28th December. The father would be at liberty to have lunch with the minor during the visitation hours. The paternal grandparents of the minor child may accompany the minor child during the visitation. The mother shall remain in the premises of the mall during the aforesaid period. The father shall not take the child anywhere out of the said mall and return the child to the mother exactly at 3. The mother shall not interfere during the visitation. Both the father and the mother would be at liberty to accompany the child during the lunch. if they feel convenient and cozy for the same, and if good sense prevail over them, and if they really want their child to get a perfect Christmas gift. The rider is optional and should not be used as a sword by any of the parties and should only be adhered to. Both the contending parties should ensure the child's safety and well-being during the aforesaid visitation, and any infringement with the safety and well-being of the child, if be reported, would invite adverse order against the delinquent. Needless to say that both parents would maintain cordial relation in front of their child and avoid happening of any kind of untoward incident or avoid exhibiting any sort of unpleasant behavior through verbal exchanges. Both must realize that such incidents, if occur and witnessed by the child, would cause more harm to the child and would affect his innocent mind, resulting in the child losing respect for his parents. One report has been filed, but this was facilitator appointed by the appointed, no, not by the court, but she was a facilitator who was the advocate on record for the respondent of opposite party.
The learned
advocate on behalf of the father raised strong objection against the said report and submitted before the court that no such report has been called for by this court, and the report has been procured at the instance of the mother without serving them any copy thereof. Let us not go into that. So from December 2025, this small issue had been going on. All that I wanted is a private interaction with the child, with the grandparents, at a place where there is to dispel with the possibility of a
compliance with
custodial parents' influence for the timing, even it could be for 1 hour or 2 hours.
Why can't it be 1 day mall and 1 day private?
Why not? Please make that arrangement.
My lord, private resident, my lord, I'll tell my lord, my learned friend should just complete this, my lord, narration by saying, my lord, thereafter, my lord, they had to request, the child was not staying with them. They had to request, my lord, my client, my lord, the mother, to, my lord, also stay for lunch. And because it was not in compliance of the order, we requested for an email or at least some kind of communication to us for stay with the, my lord, that's at page, my lord, 249.
Mother stands here and say, come here, come here, come here.
No.
And the child wants to go away.
Don't say.
So, but it does
Your
not,
own affidavit, I showed how the child reacted.
that's because of the that's because of the custodial parents' influence.
Was also present.
Yes.
That may have an effect.
Lord, today, my lord, there has to be bonding.
Custodial parent will always have an influence. This aspect cannot be ruled out. If a child is there, child's mind is absolutely influential. It
Lord,
can be
I have,
like
Lord,
a molten wax. You can always have your impression there. The child's mind is very impressive. It can definitely be influenced by the custodial parent, and there is no doubt about
Lord,
it.
no doubt about that.
The custodial parent is present there, and then there is a visitation, then in that case, that is more a reason for the visitation itself to be frustrated than for the visitation to be successful. So,
well, the visitation, my lord, was without the mother.
Yes.
To hand over and was done.
28th of December.
And was done. But my lord couldn't keep the child. My lord, kindly see, my lord, a 7-year-old, my lord, who has really not, my lord, it's his own petition. I'll show my lord the civil division petition where he says, I used to come during the weekend. That's his own version.
We can have it tomorrow because I have those extension matters. They are all waiting.
My lord, this is I'm only saying, my lord.
Your lordship has
Let,
heard
my lord,
this
this is
matter.
nothing, my lord, no, my lord.
No further development.
My lord, nothing will fall, my lord.
These orders, Mr. Banerjee and Mr. Mojumdar, these orders can't be passed by just judicial conscience.
No, correct, absolutely.
These orders are of balance.
Yes.
There is hardly any role of law to.
My lord, correct, absolutely correct, my lord. I absolutely, my lord, there is
guidelines
no law on this question.
There is no law. The desired guidelines not with a view.
Guidelines also says reintroduction.
It's only the question of balance.
Yes.
Absolutely.
Now,
Lord,
I am agreeable to the observation which fell from my lord.
The most difficult matters to decide.
Absolutely, my lord. I genuinely, my lord, I don't even.
If I find that the child is the child can't be controlled by me, should I see my child suffering and keeping him in custody? It's no.
In fact, both the parents also should see how the child is being affected by their.
That's the sole consideration.
The child is in the midst of a tug of war.
That's the sole consideration.
Absolutely. Ego of both the parents, they tear the child apart.
My lord, the father also has to see, my lord, what kind of bonding, my lord, he has with the child. Or the court also has to see. I am showing, my lord, there has to be bonding for, my lord, the child now to trust.
I would request both of you to take this cooling period of 1 day that I'll be giving to you. Come back tomorrow, and I'll love to have an order on consensus rather than.
Lord, I am giving my consent to the observation which fell from my lord.
Let us see.
My lord, from the house, my lord, it's very difficult. We'll not be able to keep the child. I've taken instruction.
There will be a third party.
My lord, I also, my lord.
If I can't keep the child, the facilitator, not the trained custodian, not the trained facilitator, will take the child to the home. of the mother.
Let us see, we'll have it
Can
tomorrow.
extend to 3 years.
लिखे नहीं. This revisional application lays challenge
If it may please, my lord, this is an income tax matter which has been specially assigned before your lordship. The interim order is expiring.
This matter has been assigned to this bench by the Honorable the Chief Justice. Full stop. We'll hear it after the vacation only, can't hear it before the vacation.
This matter can be allowed to hear out because small issue is allowed in this matter. No, not today, my lord, no. But after vacation, my lord, it can be heard.
My lord, in this matter, we have also pressed some jurisdictional issues also. So it will take some time to be heard, your lordship.
Very small point, my lord, involved.
Isn't it? Interim order is there already.
Yes,
Indeed, my lord. The interim order is expiring on the 25th
of May.
Of May. This is the last order which was passed.
It is
your lordship.
submitted by Mr. Gupta, learned advocate appearing for the petitioner, that the petitioner is protected by an interim order, which is
Expires on 25th of May, my lord. I'm only praying for an extension and a date may be fixed
I
for
am
final
actually
hearing.
the opposite party plaintiff, my lord. Kindly fixed any day after.
And as per the last direction, my lord, I've also served. Kindly.
Affidavit of service filed in court today is taken on record. Full stop. Having heard the learned advocates appearing for the respective parties and having considered the material on record, comma,
My lord, in 25th, my lord. Kindly extend, my lord. Although I am suffering.
Your lordship.
লিখে নিন।
What is it?
ওই
একটা fix করে নিন।
same order code.
Only one thing, my lord. Last time matter was fixed a particular date. If suggest by a
I'm appealing for the petitioner, my lord. This is my affidavit of service, my lord. My lord, the interim order will expire on 22nd of May, my lord.
Same order.
My lord,
Till the end of
can a
July.
date be fixed, my lord? Because
Fixing of date now before the vacation. Where is your other side?
my lord, I have served, my lord.
Affidavit of service টা লিখে নেবেন। Affidavit of service. None appears for the opposite party. None appears for the opposite party. Extended till the end of June. Next.
Till end of July, my lord.
July. Yes.
My lord, in this, sir, apni achen? No. My lord, in this matter, I am for the petitioner. My lord, the initially interim order was granted till, my lord, end of June 2025. Since there is a gap, my lord.
The other side.
I had no, my lord, I could not. So far, the initial revisional application has been served, but so far the application for extension that could not be served. My difficulty is.
When did the interim order expire?
My long back, my lord. In next last year, June 20.
Serve and come. Serve and come. It will not be proper.
The difficulty is, my lord, in the reopening of the court, my lord, there is a date before the trial court.
So you say that it is pending. What else can be
No,
done? You
my
say
lord,
that
the second Munsip, second civil judge junior division, Paschim Midnapur. My lord, he is proceeding expert. He is not taking any time. He has already fixed, my lord, taken evidence of the plaintiff expert.
I will record that you will serve and come back. I'll fix the date on the reopening date. Can 1 of 2026 is an application for reimposition of the interim order that expired on in June with the end of June 2025.
Therefore, I filed the application.
Full stop. The petitioner shall serve a copy of this application upon the opposite parties, intimating them that the matter shall be taken up next under the same heading on June 9, 2026.
I'm good.
Next.
294, my lord, I am for the petitioner. Interim order was last extended on 17th of March. As per your lordship's last direction, I have once again served the copy of the revisional application. They have received, and the interim order is expiring on 31st of May.
Affidavit of service
This is
filed in is taken on record.
This is the affidavit of service for no notice of mentioning as well.
None appears for the opposite party. For interim order till the end of July.
hearing.
তুমি এরকম করছো
I'm not that way.
Serve and come back. ওই যেটা ওই সার্ভিসের ডিরেকশন হলো Can 1 of 2025 is an application for extension of interim order. The petitioner shall serve a copy of the application upon the opposite party, intimating them that the matter shall be taken up next on 9th June 2026 under the same heading. File affidavit of service on the returnable date. Next.
'97, I am for the petitioner, my lord, interim order till this month, my lord. I have communicated the order passed by your lordship on 31st March, your lordship passed the order.
लिखे नहीं. Affidavit of service filed in court today is taken on record. None appears for the opposite party. Interim order till the end of July. Monthly list of June. Next.
बोलोगे तो यार ये तो खुद में
Order expires on the 27th of this month, my lord. It was first passed, my lord, in May 2025. It has been extended thereafter, my lord, from time to time.
Your other side?
My lord, it's served, my lord. They don't appear from time to time. They sometimes appear, they sometimes
None
don't.
appears for the opposite party. The
to the defendant's application for condonation of delay in depositing arrears.
I'm for the opposite party number
June
1.
25, expiring on 27th of May 2026.
same order. None appears. Your
No, I'm for the opposite party number 1.
hard learned advocates appearing for the opposite parties. Interim order till the end of July. Monthly list of June.
Great.
Next.
This is my application. The interim order is
You're appearing for the opposite party. Heard. Monthly list of July, monthly list of June till the end of July.
Look, 502 and 503 are analogous matter, but the number appearing in 502 is not correctly appearing in the cause list. 503 is appearing correctly. Correct number ta bolo.
2824.
2824 is the correct number.
2894 appear kuch.
Past 503 ta aage din, it will appear. 503, the CO number is correct.
নাম্বার গুলো ভুল আছে 28941672 এখানে লেখা আছে 2824 আর 1674 2824 টা 2894 হয়ে গেছে
মানে
কালকে দেবেন
নাম্বারটা একটু ভুল আছে
টু বি মেনশনড না কালকে এক্সটেনশন অফ ইন্টারিম অর্ডারে দিয়ে এটা কালকে ঠিক করে দিন নালে তো অ্যাপিয়ার করতে পারবেন
503 is correct but 502 is
দেবেন ঠিক করে দেখে মিলিয়ে নিন যা ঝামেলা হচ্ছে ফালতু একই জিনিস আমায় তিনবার করতে হচ্ছে
ওই দুটো সিও নাম্বারটা লিখে দাও তাতে লিখে একটা দাও
নাম্বারগুলো মিলিয়ে নিন
should it be taken tomorrow
yes because maybe
ঠিক নাম্বারটা ঠিক great
Yes.
Possibly, I am appealing for the opposition party number 1, 17 and 18.
It will expire on 27th of May. I have served
affidavit of service, ওটা xerox copy তো xerox নিচ্ছেন কেন?
sorry.
ঠিক নেবেন তো, xerox যা দিচ্ছে তাই নিয়ে নেবেন।
আপনার পোস্ট স্যার
ওই same order.
As
Affidavit of
Lordship,
service.
kindly
private affidavit of
extend it
service.
up to
I'm filing.
very short issue is involved, Lordship. Kindly extend it only short period of time.
Till the end of July, monthly list of June. Affidavit of service, please file.
I'm filing.
Yes, otherwise I'll not sign the order. আলাদা করে রাখবেন।
Lordship, in this matter,
let the matter be called up.
Sir, 505, I am appearing for the opposite parties.
Yes.
Lord, on 10th of December 2025, your Lordship was pleased to fix the matter at 2 p.m. This is a contested matter, where it appears from a suit for section 6 of the Specific Relief Act. I obtained a degree.
After vacation now.
Lordship.
Same.
Your Lordship is extending the order.
End of July, monthly list of June.
Any time may be fixed, because on the earlier occasion, time has been fixed.
Mention it, I'll upgrade it.
Lordship.
Here is the order.
ওটা রেখে নিন, অরিজিনালটা রেখে নিন। ঠিক করে ওই ফাইলেই দেবেন, আবার ভুলভাল ফাইলে না চলে যায়। নেক্সট।
My lord, I'm praying for extension of interim order. It has expired in February
Same order,
and
same
thereafter
order.
running in the list.
Heard আর ওই till the end of July, monthly list of-
Expired in February, Lordship. Now it's
Uh, 507, my lord. I have instruction to withdraw the revision application.
লিখে নিন এটা। Affidavit of service filed in court today is taken on record.
I am 508, I am opposite.
I'll extend it for a limited period because before the vacation I can't hear it.
And the order challenge before your lordship has already been acted upon, my lord.
Very well. After the vacation we'll hear it.
Yes, my lord.
expired in 31st May, my lord. That's a Bhattacharya is he will say because it is my eviction suit.
I have not till the end of July 2026.
My eviction suit.
Mention it after the monthly list of June. But next
Interim till end of July.
July.
August, end of August. তা তো বলবি end of August.
না আমার নাম দেবো আর্লিয়ার ডাইরেকশন পাস করে এই করেছি 31st May 31st
Affidavit of service filed in court today is taken on record.
31st May.
Opposite party?
We have served, my lord.
None of
Be heard very soon. So kindly fix it here for hearing after vacation.
लिखे नहीं none appears for
Lordship, 12 and 13, I appear for the petitioner. The interim order will be expired on the last day of May. Lordship, kindly extend.
End of July, monthly list of June.
12 and 13, analogous matter, Lordship.
Next. 13 also same?
Yes, Lordship. Analogous
13 same, 513 same. You are there in 513 also?
Also, I appear for the petitioner. This is my affidavit service. The interim order.
You are appearing? The affidavit of service filed in court today is taken on record. None appears for the opposite party. End of July, June. What is for you?
And for the opposite party, Lordship, let the interim order be extended, but Lordship, the thing is this, my lord, my lord, after the progress of the argument and a substantial part, the amendment application has been filed to amending statement. Previous the date was fixed. Lordship, kindly fix up any date, any time, Lordship, so that the matter, my lord, can be heard out.
Interim order till the end of June kore din. Ar eta upgraded motion 23rd June.
I'm grateful.
লিখে নিচ্ছেন তো দিদি ডেট ফেল নাহলে আবার ঝামেলা হয়ে যাবে
Only point is that but 151 capital A is maintainable in an interlocutory order. A commissioner's report has been filed. Against that, objection has been filed by Mr. Ali's client. That objection turned down, commissioner report accepted. Against that, 115 capital A has been filed. Now, that court entertained and grant stay. I came up before this court. Just the coordinate bench, Justice Bhattacharya, is of the opinion the revisional court has to decide whether revision is maintainable.
That maintainability point was decided in our favor.
How?
Revision has to proceed.
There is a stay capital.
Very well, we'll hear it now.
Really keep it date. Only this.
The short point is there. I am saying
we can do it tomorrow.
Yes, sir.
Tomorrow. Tomorrow,
then we have to have it after the week.
I can, but kindly keep because my client is 89. Because only
do it tomorrow. Mr. Ali, come tomorrow.
Very well, madam. Tomorrow.
Then kindly keep it after vacation because the advocate. আরে ওর কালকে ভাইয়ের অপারেশন আছে কি করব
লিখে নিন
My bad luck.
My lord, immediately upon reopening, Lordship, I'm saying that this revision is not maintainable.
Interim order granted earlier is extended till the end of June করে দিন আর upgraded motion 10 June.
Lord, agreed.
Before your lordship.
With your lordship's liberty, may I mention a matter?
Yes, madam.
My lord, there is item.
I'm yet to conclude, madam.
All right, so
listed
sorry.
matters. Yes.
Yes.
I am appearing for the opposite party, my lord.
Wait, let the matter be called on. Yes, yes.
My lord, I would beseech your lordship to take pain to come to the last order, your lordship, by which the stay was granted.
Who is appearing for the petitioner?
My lord, there.
My lord, I am appearing for the petitioner. I beg to appear on behalf of the petitioner on virtual mode, your lordship. My lord, the stay has been granted.
Why are you not in
My
court?
lord.
Why are you in car?
My lord, I was traveling on another matter, my lord. I should have been there, my lord.
My humble submission in this respect, my lord, your lordship kindly take me to come to the paragraph number 5 and 6, whereby your lordship was lordship was pleased to direct them to go on depositing the rent. And second part was that to serve the copy. My lord, both these part have not been complied with.
Why have you
this
not
interim
My
order-
lord, my clerk is there with the affidavit of service, my lord.
No, I have not been
Mr.
served. After getting the
He is there with an affidavit of service. Please check up with your client.
I am not in this matter. His clerk
Very well,
requested me
yes.
to submit.
So,
no, I have today. I
My
have
lord, affidavit of service, my lord, will show that the item has been delivered, my lord, from the address.
Moreover, my lord, they are not paying the.
Check it up for yourself, sir.
My lord, by a later dated 13th of April
You
2026.
Please wait. Hold on to your horses.
My lord, my lord.
लिखे नहीं affidavit of service filed in court today is taken on record. Full stop. Learned advocate, Mr. Sachin Sach, onar naam record kore neben. Mr. Sachin Sach appears and submits that he has instructions to represent all the opposite parties.
Yes, sir. There are only one opposite party.
Opposite party, which one?
Lord, opposite party number one.
Opposite party number 1. But no copy of the revisional application has been served upon his client. Full stop. However, comma, such fact is refuted by the learned advocate appearing for the petitioners. Full stop. To cut short the dispute, let a copy of the revisional application be served upon Mr. Such and Such, appearing for the opposite party number 1. Full stop. The interim order granted earlier.
Lord, may I only
is,
one thing, Lord.
is
They are not
extended.
depositing the rent in terms of
You take steps.
It is your lordship's order. Your lordship kindly appreciate.
Extended till the end of July 2026 or until further orders, whichever is earlier. Full stop. List this matter as upgraded motion on June 11, 2026. Full stop. It is submitted by the learned advocate appearing for the opposite party number 1 that the petitioner has not been depositing the current rent in terms of the provisions of section 7(1) of the 1997 Act. If such be the case, comma, the opposite party number 1 is free to take appropriate steps in terms of section 7(3) of the 1997 Act.
Your lordship was pleased to grant them interim order. Lord, don't take me otherwise.
I have also granted you liberty by the same order, sir.
This stay was granted in the garb of that condition.
There is no stay
So
granted in
that
the
condition has
garb
not
of
been
any-
fulfilled by them. That is why I'm purely.
My lord, I am.
If he's
So,
not
Lord, they are
complying with that,
enjoying the interim order by not
sir, you
paying.
don't
the-
understand English. What did I just now dictate?
Your lordship has directed.
You must follow that.
My lord, 518, I appear for the petitioner. My lord. I am praying for extension. My lord, it's expiring on. My lord, I am.
For the opposite party, my lord,
Yes.
I am objecting on that. My lord, they did not have a copy upon us, first of all.
My lord, we have served upon the party.
Before the vacation, don't
And another
object to
thing,
the
my lord,
extension.
my lord, I am saying before your court, kindly added learned GP in this matter because this land belongs to the government, my lord. How they have filed
See,
this
here I will
thing-
not add. You go and pray for addition before the learned trial court.
I am praying for extension. It's expiring on 31st of May.
And on the strength of the
Having heard the learned
Honorable High
advocates
Court order,
appearing
they
for the
have filed
respective
this
parties.
matter, my lord. Vishwas Ranjan Niyogi, erstwhile.
Not today, you come and argue tomorrow. Upgraded motion tomorrow. Come and argue.
My lord, kindly.
No, you want to argue, you come and
My
argue.
lord, kindly extend and give me.
Why? You wanted to argue. You cannot go on like this. It is appearing under the extension. I am going to extend, fixing it after the vacation. You want to argue, come and argue tomorrow.
My lord, kindly fix
No,
it.
you come and argue tomorrow. Appear as upgraded motion tomorrow. You
Kindly
please
allow
argue
me
your
to
case.
file opposition, my lord.
No opposition. You argue your case first. This is
No,
revision.
my lord, I am pardoned. I am pardoned.
Why? I am giving you opportunity to argue.
My lord, I
You
am
don't
seeking
kill the time unnecessarily if you are not ready. Then, having heard the learned advocates appearing for the respective parties, the interim order granted earlier is extended till the end of July 2026 or until further orders, whichever is earlier. List this matter as upgraded motion on June 24,
My lord, in the
2026.
meantime, may I file an opposition, my lord?
Opposition is not required in civil revisional applications. Yes, madam.
For your lordship,
My lord, there is an item 315. I'm asking it to be taken up tomorrow. It pertains to the custody of a child. The mother has the custody according to German law. She's a German citizen living in Singapore. The court has said that it has jurisdiction, which I submit it doesn't. And we filed a habeas corpus before this in Goa. But despite that, the person, the putative father, has brought the child to Calcutta and has tried to create jurisdiction. We are saying it doesn't have jurisdiction because he's removed the child from Goa and brought to Calcutta. So I'm only asking that it may be upgraded for tomorrow, my Lord, high up, so that we can have a hearing, because she hasn't seen the child for 2 months.
315. Give the slip.
My lord, before your lordship may rise, my lord, kindly remember this matter was not appearing under the extension of interim order. The matter was CO number 3678. That matter was appeared on, my lord, on 18th, my lord, tomorrow. My lord, kindly make it 2 p.m. my lord, tomorrow at 2 p.m.
No, 2 p.m., 3 p.m. It will appear wherever it is to appear.
Before your lordship
Don't
rises, Lord, under compelling circumstances mentioning on matter item number 62. Lord, interim was not I paid for interim order in the execution proceeding. Your lordship fixed an early returnable date. It is item number 60, it will not reach. Lord, that's why your lordship kindly item number 62.
62 upgrade করে দিন।
Lord, tomorrow Lord
কালকে দিয়ে দিন।
Your lordship, the other side senior advocate is here. What time can it be taken today? Mr. Vaid is
Yes,
here.
Mr. Bad. It's a hearing matter, but he wants to get it heard before the vacation. He is in some kind of difficulty because he is without subsistence allowance.
But he is dismissed. This question of subsistence allowance. That is.
He wants to take his chance before the court in any case. Today we have fixed matters. I don't know when we'll be able to take it up. Problem is, before the vacation, you see the rush. Hearing matters, if I take up one hearing matters, I'll be cursed by 1,000 people.
Sir, then at least I'll request your
Object to lordship fund. My matter is passed over.
We can have it after the vacation, Mr. Banerjee. Because
why they want to have the stay order for a 6 years.
Yes, deprived all the.
why don't we get an adjournment in the trial court on the next date?
Let him file an application on next date.
I'll make that order. I'll fix it that you will not be objecting on that day. ওইটা একটু call করে। I'll come back at 2 p.m. and I'll do this because it's
your lordship, your lordship, I just would like to just a minute.
In your lordship that
tomorrow.
If your lordship is willing to take it after vacation, my humble request before this honorable court that on the 3rd of June the next date is in the trial court. At least kindly pass an order that so no adverse order is.
That order I'll pass. What of June? We should wait till the hearing.
Till maintainability the hearing of. Then stay of the suit, my lord. The stay of suit.
Don't be stay of the suit. I'll say he'll post a date later than the date on which the revision is returnable. That order.
Till the date of a hearing of the maintainability.
No, not till the date of hearing.
Okay.
Just one day.
Okay.
Come back at 2 or maybe tomorrow, whatever suits you.
Tomorrow would be.
Tomorrow.
Tomorrow, That's grateful.
Labor lost.
I was discussing with my learned friend how to persuade your lordship otherwise.
It will not be. We are in a very vulnerable position, Mr. Bose. This position is very vulnerable. It's very easy. All the good work that you do may go down the drain for something which has no reason.
And there is nobody to.
Yes. You yourself also cannot defend your own self.
Correct.
There are very few orders wherein both parties go home happily. I think this was one such order, perhaps.
I also did what I thought was absolutely justified, but then circumstances, it came to my notice while I was finalizing because there are a lot of typos. I do it myself. Then I was looking at it. I came across the jurat portion, the affidavit. Then I read it. Said no, it becomes difficult. Dekhi din.
Then, my lord, may I pray for one indulgence? Then, would it be a sincere lordship is recalling that order?
That's the
But that order will not get, it will not reach the server.
Can't. It will only reach once I sign. Once I sign, I lose jurisdiction. I will not be able to recall also.
No, I mean, your lordship can recall.
No, but that will become difficult.
Okay. Very well.
Once
Your
it
lordship
goes in
indicates that came to your lordship.
Yes, that I will do. लिखे नहीं. This
সে তো
matter,
করেই দেবে। Well, even 23 was the connected matter.
that will also be released. That will only be released without this introduction.
Wait.
It was embarrassing for me also, but this
I
is
can
the course
understand.
which I think is proper.
No, absolutely.
23 the একই singular order.
না 23 তে শুধু রিলিজড হবে 23 তে লিখে নিন সমরদা
রিলিজ হবে কি করে
23 তাতে শুধু লিখে নিন
ডিকটেশন দিচ্ছে তো
this order is released this matter is released from this list on my personal grounds full stop let the same be placed before the honorable the chief justice for appropriate orders.
My lord, kindly indicate that since the other matter is connected, so then both will go to the same bench. Otherwise, again, that
it will go to the same bench in any case.
No.
Because both the orders will be going before the honorable.
No, what I was respectfully submitting, if your lordship indicates since I have released item 1 and item this 23 is connected to item now 1, I am releasing this as well. So then
I'll indicate that.
Yeah, well, if your lordship does, then both will go. Matter.
In the same.
লিখে নিন ওখানে লিখে নিন
Just one sentence, I think, should suffice.
Since CEO we আগে আজকে 2 PM কিছু ফিক্স নেই? 3 PM আছে। Yes.
Lord, here I have, my lord, challenged the order passed by the BT tribunal, which has, my lord, affirmed the order passed, my lord, by the special officer building. Now, my lord, there was a unauthorized construction, my lord, which was regularized. And there was a, now, my lord, thereafter, my lord, fresh 401 proceedings were initiated. And, my lord, found, my lord, unauthorized construction, further unauthorized construction of 29 meters. My lord, that, my lord, had culminated into a demolition order and, my lord, affirmed up to the building tribunal. Now, my lord, the main problem is the learned tribunal had ventured into the, my lord, demolition on the regularization aspect also. My lord, 29 meters, my lord, it's not, my lord, such a huge construction, my lord, initially, my lord, there were which were regularized. Thereafter, still they found unauthorized construction to the extent of 29 meters, my lord. That, my lord, my scope of regularization is also closed, my lord, by the impugned order also. But regularization has been rejected on merits. Well, along with my, along with the other BT, other points in the BT appeal. My lord, this is, my lord, regularization, my lord, to give or not to give, my lord, is the sole prerogative of the, my lord, the, no, not the SOP, the commissioner of Kolkata Municipal Corporation. My lord, if your lordship would kind enough to come to, there is no paragraph, page 12 of the impugned judgment, page 12, 9.4.
9.4.
Here, my lord,
why do you say he is incompetent to?
Commissioner is the authority. Commissioner is the authority.
The tribunal doesn't have the
Tribunal
authority.
cannot be. Commissioner is the authority.
Against the commissioner's order, will the tribunal not be competent
That
to
is,
hear appeal?
in that case, commissioner will act as the appellate authority. Here, my lord, the first, my lord, there was also fault on the my counterpart in the trial court. My lord, kindly see the specific argument was there was no justification on making, but tribunal.
He raised the argument, he has dealt with it.
My lord, that is there, my lord. Court should not have gone into that aspect at all.
Then if the aspect is raised, then there
Court
will be a problem.
Court
If the aspect is raised and the court does not deal with it, then
court could have
will face the wrath of the higher court saying that it was raised and you have not dealt with.
Court could have, my lord, the learned tribunal should have dealt, relying upon the statute that this does not come within the ambit of the tribunal to decide that.
Very well. How are you aggrieved by this observation? You are aggrieved by.
This is one, and now, my lord, kindly comes to, my lord, if your lordship would kind enough to, my lord, the infringement statement, my lord, kindly comes to, my lord, page 5.
Page 5.
Yes, my lord, of the judgment.
Page 5.
Kindly see, my lord, the infringement statement, my lord. What can be, my lord, in permissible sanction provided remarks. My lord, this is, my lord, what is the, he has quoted, my lord, the order of the SOB here only. What have I?
Where is the order of the special officer building?
Not with us, my lord. That was a chicken air. Naturally, I'm a junior name. Page 18A. Page 18, my lord, type copy is at page 18A. Page 18. Again, my lord, this is not permissible in view of, my lord, the Laddu Gopal Bajoria's judgment, my lord, the nature and extent of unauthorized construction, where, my lord, no particulars. And the last part is, my lord, the cost, my lord, huge cost has been imposed upon us.
To me, that only the commissioner can take this decision as regards. I don't have Kolkata Municipal Corporation Act. Which provision?
400 subsection, may I find? May I read? Okay.
I have got one.
Oh, so
400.
my lord, the third proviso to section 400 subsection 1. Provided also municipal commissioner may by order on such terms and condition and on payment of such fees as may be prescribed by regulation regularize minor unauthorized erection or execution of any minor work without sanction under this act or minor deviation from the sanction.
That is his power of regularization.
That is his power of regularization.
Regularization.
We have not exercised that. By
That
this
doesn't
order,
show that the building tribunal has no jurisdiction to rule on this.
no, provided, my lord, we apply and he rejects. Then, my lord, an appeal lies under 400 subsection 3. This was not an, kindly see.
It does not require an application. Municipal commissioner can regularize on his own also.
No.
Why?
The format,
There is
where
that
that,
provision
that is the 15 rules, my lord. I have not brought, my lord, that 2015 rules. Format, online application, everything is there.
For regularization, application is mandatory.
2015
Provision does not say so.
No, provision does. The rules has come, my lord, regularization, my lord, Kolkata Municipal Corporation.
The provision should say that it should be in terms of the rules prescribed. That is also not said.
2015 rules. No,
It only says on payment of fees as may be prescribed.
Yes.
Not
yes.
on making an application in the prescribed form or anything of that sort.
And, my lord, if your lordship kindly sees, my lord, annexure P, annexure D, my lord, here, my lord, there is no particulars at all, only 29 meters. This is the rules, my lord. This is the last one.
But this also does not speak about application.
Application does not speak about application.
That is what I said. It cannot be inconsistent with the provisions. It is his power. That is
Power.
why your learned advocate argued that
Yes.
he has power, he did not exercise it, and therefore he says this.
Power, it was not.
Yes, that was the
argument. Yes, that is the argument. That is the argument. But he has not exercised this, my lord.
So it is in that, it has to be read in that context. It is not that it is an incompetent observation. The observation he is authorized to do because this observation was raised.
Yes.
This
But
question was
the
raised.
municipal commissioner has to take a call first.
Municipal commissioner has not taken a call, therefore he is aggrieved. Not taking a call, and that has been answered. That is also a way.
Then
to
we
look
are
at it.
jumping up for him because
No.
under if
You-
he had
you-
rejected
if you
my
aggrieved- if you are aggrieved by the inaction, because not taking a call is also a sort of
inaction.
refusal, or refusal also. I have not approved. So for not approving, a particular order is not required to be passed unless you make an application. If you don't make an application and I don't approve, that means I have not found it fit to be approved. So therefore, this part, I don't think. Your other ground, you tell me whether how on other ground the order is.
No, my lord, the other ground, my lord, the court says, my lord, if your lordship would kind enough to see, my lord, the SOB's order, my lord, kindly see, my lord, the order of SOB. Page 18, my lord, annexure D.
Page 18.
And nature and extent of unauthorized construction is also not given, my lord. Kindly see. Extent is given 29.66, but
No, but this is not the order of SOB. This is executive engineer.
well,
Page
this is what was challenged.
No, but special officer buildings order is a reasoned order. This is just a notice.
No, ordered at my lord, at
But
the
SOBs are SOBs not judicial officers? They are. That is what we have seen.
my lord,
They can't be executive engineers. Executive engineers are not authorized to pass orders.
yes, my lord, this was challenged under. Kindly see the first page of the tribunal's order. An appeal under section 403 of 1980 arising out of the order dated 24 July 20 passed by the executive engineer Boro 2. And this is the page 18 is 24 July 2023.
If executive engineer is authorized to pass order of demolition.
Yes, by the my lord, municipal
Delegation of
commissioner delegation is there. Power of delegation, justice standards order, my lord, judgment.
This order is unreasoned that way.
Lordship knows, my lord, Laddu Gopal Bajoria's judgment, my lord, nature and extent of the unauthorized
What is he referring to?
Yes, what is he referring to, my lord? It was, there is a plan. my lord, what happened, my lord?
According to you, you have done it in accordance with the plan.
No, there was deviation which was regularized. Subsequently, my lord, they again found, my lord, unauthorized construction. My lord, this is what they say, my lord, after regularization.
So according to you, after regularization, there is no unauthorized
No,
construction.
no.
Problem is from this, it is difficult to make out what it wants to say.
My lord.
From page 18, it is difficult to be made out as to what
Exactly,
it wants to say.
exactly.
Okay, cool. This revisional application is directed against an order
On the last day, Lordship has observed that
Other
if
side was there in the
in
morning.
the first call, they again took time, then they never turned up. We have informed them yesterday after Lordship's observation.
You know who they are? Don't know.
The lawyer who came here in the morning said he is not briefed, but he was informed by someone to take a passover. So then Lordship, that was passed over in the morning. Then Milord again, now I don't think anybody is there.
By this order, comma, by this revisional application, comma, the
Rule 8 for impound about a particular deed, but that application was allowed. But when a report was sought for from the collector by the learned trial court, instead of stamp duty, it was wrongly written as a court fees. If you also kindly see just only two orders, but kindly come to order number 56 dated 14/12/2018.
order number
56.
56.
56.
Yes.
Got it? Kindly see the third paragraph. Peruse the case record. It appears that White later dated so and so The petitioner in chair sent a letter addressing to the district magistrate Purulia seeking for necessary arrangement for assessment of stamp duty for the purpose of impounding of the said document. That is the unregistered deed dated so and so. But due to some typographical mistake, in place of stamp duty, court fees was put on the said letter. It further appeared that void memorandum, it has been due to this fault, subsequently, I filed a further application with the learned trial court. Since in spite of this direction, no stamp duty report has been submitted by the collector, by the order impugned, that is page 70, order number 74. The learned trial court suo moto lordship at its own motion recall the order of lordship impound. May I read? The defendant have stated in the instant petition that the returner has produced a kacha sale deed so and so, and the sale deed has been impounded by this court in previous order. A direction has also been sent to the collector of Purulia to send a report regarding the amount of the registration cost of the said unregistered deed. But any report has not been sent till date. Thus, the defendant have filed the instant petition with a prayer to give direction to the district sub register Purulia to send a report. Hard considered upon careful perusal of the case record and the instant petition, this court is of the opinion that in view of order 3913 rule 8, CPC, the instant petition filed by the defendant is not maintainable in the eye of law, as the said deed is an unregistered instrument, so it is not required to impound it for obtaining the information regarding the amount of registration of cost and the same anymore. Hence, the instant petition filed by the defendant, the order has been recalled, which was passed by the petitioner of the court. Now, initially, I should have initially I filed a revisional application before this honorable court. This honorable court passed an interim order in my favor, but subsequently there is some defect in the revisional application. I withdraw the same and file this application. So this is the earlier order passed by your lordship.
This revisional application
27. But I have filed this application challenging the calculation part, internal page 8 of the order passed by the learned civil judge. It is simplicity are calculated taking course of 90 months. Can you take the calculation? Page, internal page 8 of the order dated. Is the order dated?
Internal page 8.
24th of March.
Yes, yes.
Take that 90 months due divided by 12, meaning there by 7.5 years. Now calculation has been made. Principal is 15,525 is correct one. Now on 10% of that, the learned judge calculated in this way into 10% into 7.5. This should be from the date of inception of 90 months. Thereafter, it should be reduced. But I have made a calculation at page 19. But I have learned from the judgment of two honorable division bench. Elaborate discussion has been given. How calculator is to be given. I have learned. But I did not know this. After filing, I have got this. But kindly take page 19.
Page 19.
19. Interest part, how it is to be calculated. Thereafter, I shall go through the judgment. Well, I got it. Because the learned judge is doing in all these matters of the particular court.
Page 19 I don't have.
19.
Yes, I don't have page 19. Page 17 is page 18, 19. Yes.
Well, can you take the amount of per month rent 172.5? 10% would be 8.33 or 8.13 of that 90th month, particular month. It comes to 129.375. After that 89 month, it will be reduced. And up to the last month of 90 months, it will come to that 1.43, bottom, last, right hand side. And if I add all these interest, it comes to 5,886 instead of 11,000.
Where did you get this method of calculation from?
Yes, I am so grateful. Kindly take the that order judgment of Malaysia Justice Sarkar was not in your lordship's file, but I have checked it up. Now I am handing over. In this case also calculation had been made at page 3. The way learned judge in my case was pleased to calculate. This calculation in this year is not the correct one. Now my lord asks me how this calculation would be. My lord, take the judgment of Malaysia Justice Mukherjee. Taking course of other judgments, this was can you take the judgment of Malaysia Ajay Kumar Mukherjee. It is reported in 2025 3 CHN 216. That judgment is there. Last day I handed over last week.
Yes.
Now take paragraph 9 onwards. Quoting the judgments, how it is to be calculated, it is indicated. In may I read for your lordship? In view of the above, it is quite clear that under the present statute, the tenant is required to deposit all area rent together with interest at the rate of 10% per annum. Under the old act, it is under the 1956, the interest was payable at the rate of 8.13 per annum from the date and which amounts was payable up to the date of deposit, which clearly suggests that the interest under the earlier act was to be calculated by every month such and such. Now, however, it is to be noted that the legislature has retained the word per annum, which also there is earlier act which says at the rate of 1/3 per person. Though the section 7(1) appears to be not happily drafted, but it is obviously then the legislature has retained the word per annum. It does not mean 10% of the total area of rent. And it has been calculated total area of rent 90 months, that is 15,000 into 10%. The word per annum literally means by the year, every year, annually or yearly. So therefore, the calculation of the 10% would be from month to month basis. 90th month, 89 month, it will be reduced the last month of 10% of that particular amount of rent. And Justice Sarkar also, my lord, was not in consonance with the calculation of the paragraph 12 is very much clear. If the interest is charged upon 10% per annum on an outstanding amount, it means the person concerned needs to pay an additional 10% of every year until the end of contract. Paragraph 14 kindly sees the direction. Paragraph 14 of Maharaj Mukherjee's judgment.
Paragraph 13, he's right.
13 of the Justice Mukherjee, Mary. The rent becomes payable on the basis of contract between the parties, either orally or in writing, in absence of any agreement contrary. The rent of particular month become payable on 15th day following the next month, following month. When the rent of that month becomes arrear, since the legislature has not used the term 10% of the total arrear rent towards the interest, then logical mode of computation of interest upon the arrear would be that the interest is to be calculated every month's rent, taking into the account.
Yes.
Every month's rent.
Yes.
Yes.
Taking
The
into account.
period then it was actually
Paid,
deposited or
yes.
paid.
The day when you actually deposit, up till that date you will have to pay interest.
Yes.
So if all the dues have remained, all the installments have remained due till the date you are actually depositing it, he'll be entitled to interest
Yes,
on that. What
that
is
is why
wrong in that?
calculation of every month. Suppose I am giving one example. 90th month, 90th. That is 100 something. I have
For
calculated.
the last month, if you have paid in time, on that month you may not be required to pay interest.
That is
but
how
all the arrears.
Yes. Calculating that 132 of that 90th month into 10 years. I have to carry that interest from the 90th month in case of 90th month up to date. Now, I have to pay again interest. That is why 10 is year of not payment is
correct. I have got it. Because the second installment is only due for 89 months. The third is due for 88 months.
Correct.
That is how you want to say.
It is true. It is true. I am so grateful to you. It is true. Multiple by 89, multiple by 88, and that adds 5,000. And if I carry that simplicity at 10% of 7.5 years, then I have to be paid the last month's paid into 90. If I take at a glance one way.
Right.
So
He is appearing for the opposite party.
Non-appeared, refused, Your Lordship, that is why fix the matter is short matter already, Your Lordship, gone through the, let it be, send it back. And I'm so grateful that I was also confused at the time of
Not today. Thank you. Yes. That is what was prayed for. Not a problem. Tomorrow.
And so good.
BPM fixed ছিল তো একটা We'll come back to the main list when this is over. Should be. It has been kept for it to be over only. Otherwise, I would have posted it after vacations.
So we can,
have
your
a lot
lordship
of
can
time.
fix it, yes.
I shall be asking for stay. That's why I thought I would travel by lot today or tomorrow. Maybe any day, lordship.
So it will be there wherever it is. You mention it, I'll upgrade it if you want an upgradation before 16th of July.
16th July, I must get the.
Yes, you mention it in usual course, I'll upgrade it. I have been upgrading matters every day.
Well, let us have something effective for us today.
29th of all. There is a sudden rush of custody matters just prior to the vacations.
I see.
Very well. लिखे in. Mr. Mitra is for
My lord, in this matter, my lord, I had started by answering, my lord, one of the prime contentions of the petitioner, that since there is a forum selection clause, without deciding the jurisdiction issue, can the court pass an interim order either at the ad interim stage, particularly after it was pointed out, and more so at the appellate stage. And this was the broad issue, my lord, which was argued before your lordship, which I was trying to answer. Now, in answering that, I have shown your lordship, my lord, the reliefs claimed in the plaint, which is in the nature of a declaration that the agreements in question, or to be precise, the SHA or the shareholders agreement, is to be void and, my lord, consequential release. I have shown your lordship the release. But I have also shown your lordship, my lord, the forum selection clause, which is clause 22, which is in two parts. 22.1 says that English law will apply, and 22.2 says that 4 categories of cases, if it is shareholders this, courts in England will have exclusive jurisdiction. I have shown your lordship that. But I have also shown to your lordship, my lord, the clause by which there is this, the buyback clause, and, my lord, the tranches in which, my lord, if I don't perform, then they can put the money in trust and all that. I have shown your lordship that. I have shown your lordship certain provisions of FEMA. I have shown your lordship the guidelines, and in particular, my lord, guideline, my lord, where lordship has been shown that I have first shown Rule 16, and then I had shown, my lord, Regulation 9.4 of the 22 Overseas Investment Regulations. I had shown your lordship that.
And FEMA, you have shown section 4, section 6.4, section 2.0, section 8, and section 10.
Right. And main importance is, my lord, that 16 of the regulation.
Yes.
Rules, sorry.
Investment rules.
Correct. So, my lord, my first submission is, so far as jurisdiction is concerned, I'll just formulate it and then proceed further. That, my lord, if the reliefs claimed in this suit or in the suit filed in India cannot be granted by courts in England, my lord, the forum selection clause in my respectful submission is otious. It has no application. Second,
yeah, just a minute. Yes.
Assuming for a moment, my lord, it can be, forum selection is enforced, my lord, English courts will not have the jurisdiction to decide as per English law whether it is in violation of a law in India or not.
Yes.
Thirdly, my lord, the first court otherwise has the natural jurisdiction, my lord, because it's an admitted position, part of the contract executed here, part executed outside. It is not a lack of inherent jurisdiction. There is a natural jurisdiction, and also the performance of the contract. I had shown your lordship that provision that I am to deliver the shares from here, and whatever money is there, I have to repatriate because of the Indian law, well, within 90 days to India. So performance, part of the performance or the final performance has to be in India, because my delivery has to be from India, and, my lord, the repatriation of the money also has to be in India. So, my lord, the court, the Indian court otherwise has natural jurisdiction. So, my lord, if the court otherwise has natural jurisdiction, and if lordship accepts my submission that the forum selection clause is no bar, or to put it differently, the English courts cannot grant the relief that has been sought for in the plaint, in my respectful submission, my lord, so far as jurisdiction is concerned, there cannot be any difficulty. This is my submission so far as jurisdiction is concerned. Now, my lord, I had shown to your lordship Article 16 of the Articles of Association, where, my lord, the sequence required for the transaction to deliver the relevant share certificates against payment of the sale of shares, or, my lord, the buyback of shares, my lord, that has been narrated. Article 16. Well, that should be at page 327 of CO 4439. I am not reading it again. I am just summarizing what I had. And, my lord, the article I had relied was in furtherance of my submission that today, my lord, I had submitted, if today the interim orders or the interim protection, whatever I am enjoying, is vacated, and, my lord, let us say they put that money in trust, and, my lord, that money is there and they buy back the shares. Then, my lord, I have to repatriate that money because, my lord, even if I keep it there, it will be treated as a violation of FEMA. Or otherwise, if I bring in here, it will be a violation of FEMA because, my lord, I'll come to that the transaction has to be not, my lord, what the contract says, that it has to be on an arm's length basis, and I'll come to that, what it actually means. This is, my lord, one part of the submission. Now, my lord, in this context, my lord, I want to cite a Bombay High Court judgment. Ano, bhai, judgment ano. I just go on another point, my lord. I am told the judgments are coming. My lord, I was citing the Bombay High Court judgment, my lord, only on the point, my lord. In Bombay High Court, my lord, the case was reversed. The foreign entity filed a suit over here, trying to enforce what would have been an otherwise valid contract under the foreign law. And, my lord, over here, my lord, the court held that no, if that contract, which may be perfectly valid in another country or as per the laws of another country,
Would have filed it there.
if that is not valid over here, or it is otherwise not the performance whereof, if it is in India and Indian law does not permit that, then you can't have it. But I just cite that, my lord. Kindly allow me to move on, my lord. Let the judgment come. I don't want to waste my lord's time. Now, my lord, in this, I understand, my lord, one argument has been advanced. Lord, they have relied on 2020-11 SCC, page 1. And in particular, paragraph 88. Which was, my lord, under section 48 of the 1996 Arbitration Act. Lord, this was relied upon to contain that even if it is in violation of the Foreign Exchange Act or FEMA, that Lord, the award was held to be enforceable because it would not be in contravention of fundamental policy of Indian law. That was the ratio of 2020-11 SCC, page 1. Now, my lord, lordship will kindly bear in mind, and I'll cite another decision where, my lord, this distinction, Supreme Court itself has made this distinction between the parameters of section 48 of the Arbitration Act vis-a-vis section 13(1)(f) of the Civil Procedure Code. Lordship recalls, my lord, I had submitted, let us assume they get the decree, they want to enforce it here. They will have to, my lord, cross the gate of section 13. Now, my lord, the language used in section 13 of the Civil Procedure Code is slightly different from that of section 48 of the Arbitration and Conciliation Act. Lord, section 48, if lordship, my lord, sees of the Arbitration Act, or lordship can make a note, Lord, the expression used is fundamental policy of Indian law. And, my lord, in that case, 2020-11 SCC 1, para 88, it was held that no, it may be in violation of FEMA and FERA, but no, it can't be said that it is in breach of, or it is not in fundamental policy of Indian law is not this. But we'll at the language in section 13, breach of any law in force in India, 13F, where it sustains a claim founded on a breach of any law in force in India. This is what it says. Supreme Court test. But before I show that para 88 of 2020 11 SCC page 1, Lord, may I first show your lordship 2026 SCC online. SC 648. এটা একটু দিয়ে দিন।
এগুলো আলাদা রাখবেন, সব একসঙ্গে রেখে দিয়েছেন, ওটা হোটেলের আলাদা করে নোটসের আলাদা রাখবেন, নোটসের সঙ্গে রাখবেন, নোটসে আলাদা রাখবেন, সব মিশে যাচ্ছে, জাজমেন্ট আলাদা নোট।
That kindly comes to, my lord, the heading just before paragraph 54. That should be, my lord, in printed page 23 of the SCC online edition.
Yes.
The lordship will mark the issue 2, whether the judgment is unenforceable in view of the condition imposed by RBI in exercise of statutory power under FERA. My lord, here a foreign judgment was sought to be enforced in India, and my lord, it was found that it is in violation of FERA. Now, my lord, kindly come to page 50, para 54. In view of our decision on the first issue, it is not necessary for us to delve into the present issue relating to bar of enforceability of foreign decree in view of the RBI communication dated 3rd September 1997. However, as substantial arguments were advanced on this issue, we will proceed to give our opinion even on this issue. There is no dispute about the fact that the mandatory requirement for obtaining prior permission of Government of India as well as that of RBI was secured by the parties before availing external borrowing. However, the question relates to the consequence of the conditions imposed by RBI while granting permission by its letter dated 3rd September 1997. In other words, whether the condition in case of invocation of guarantee no liability whatsoever will extend to the Indian company would operate as an absolute bar to enforcement of all times to come as contended by Mr. Chidambaram. Well, kindly, my lord, this was the contention. Kindly straight away come to paragraph 83. I showed your lordship the contention of Mr. Chidambaram. Now, my lord, kindly see the findings. Section 48 to distinguish করেছে সেটা লাগে। Now, my lord, this 83, in view of the above discussion, my lord, here, my lord, what was involved was, my lord, the provisions of, my lord, the predecessor of FEMA, the FERA, Foreign Exchange Regulation. In view of the above discussion, we have no hesitation in rejecting Mr. Chidambaram's submission that there is absolute and total bar of enforcement of a decree by virtue of the conditional permission in its letter dated 3rd September 1997. This submission is therefore rejected. In the normal course, a party obtaining foreign judgment can seek enforcement in India if such a judgment qualifies the test laid down in section 13 of CPC. The central government or RBI can exercise its regulatory power under section 47(3) of FERA and grant its approval before any steps are taken for implementing the judgment. Returning to the facts of the case, in view of our finding on issue number 1, that foreign judgment is violative of requirements of section 13 CPC, our finding on issue number 2 will have no consequence. We have decided issue number 2 in view of the fact that detailed submissions were made by both parties. We also considered it necessary to clarify the position in view of the text of 47 of FERA, coupled with its interpretation by Bombay High Court. Then, my lord, kindly come to para 86. However, for reasons already recorded, we are of the considered opinion that foreign judgment suffers from fundamental infirmities under B, C, D, F of section 13. The adjudication by way of summary judgment in presence of bona fide triable issues renders the judgment one not delivered on merits within the meaning of 13B. Further, the failure of English court to give due effect to statutory permissions and conditions imposed under Indian foreign exchange law attracts the mischief of section 13C. Despite triable issues, respondent was not granted leave to defend, which stands in the teeth of clause D of section 13. The enforcement of liability contrary to binding statutory conditions also brings the decree within the prohibition contained in section 13F, being opposed to the law in force in India. Additionally, while the foreign judgment satisfies certain procedural requirement, it nonetheless. So, my lord, this was a case of section 13. Now, in this background, if lordship takes, my lord, section 48 once and sees the 48 of the Arbitration Act and sees the language, section 48 of the Arbitration Act, my lord, enforcement, I'm sorry, my lord, at a copy on Arbitration Act. May I hand over to your lordship a soft copy, my lord?
I have it.
Section 48.
I have it.
Lordship. Arbitration. But I showed your lordship section 13 because the judgment itself quotes the section. Now, my lord, the closest or the parameteria provision in the Arbitration Act is section 48 because, my lord, the 2020 11 SCC was relied upon, my lord, by the petitioner, my lord. This was a case under section 48. Enforcement of a foreign award may be refused at the request of a party against whom it is invoked only if that party furnishes to the court proof that. And, my lord, kindly come to subsection 2B.
Public policy.
Also be refused if the court finds enforcement of the award would be contrary to public policy of India. Well, it is of a much wider or, my lord, a restricted ambit, but, my lord, so far as 13 is concerned, lordship has seen, my lord, if it is
wider,
it's of a much wider ambit. Because, my lord, 13F, it may be permitted, well, it may not be, let us say, barred by, it may not be a fundamental policy, but 13F, section 48. But, my lord, 13F, if it is in violation or if Indian law doesn't permit a certain thing, my lord, such an award will not be enforced. This is, of course, the reverse. If they get a decree and try to enforce it in India, well, that is why I had started with section 13. I am trying to argue that what can be used as a shield, well, this has been used as a sword, and, my lord, it is permissible in law. That is my endeavor to show. So, my lord, if I put it the other way around, they would have got a decree and tried to enforce it here. My lord, exactly this would have been set up, my lord, by way of defense under section 13. And, my lord, my respectful submission would have been that courts in India, if they find that it is in violation of FEMA or income tax, whatever it is, my lord, the courts in India would not be inclined. Now, my lord, I come to the Bombay judgment which I was referring to. Fortunately, it has come now. My lord, it is AIR 1988 Bombay 157.
Yes.
Lord, kindly first takes, my lord, paragraph 1. Lordship will note, my lord, the plaintiff is a foreign company, my lord. Taprogue Gesellschaft appears to be a German company. The plaintiff company engaged in the business of manufacturing cooling water filters and allied products incorporated under the laws of Federal Republic of Germany seeks a declaration that the defendants, an Indian company, and the plaintiff's erstwhile agents in India are not entitled to sell or offer for sale two of the plaintiff's products known as Taprogue cooling water filters and Taprogue condenser tube clearing systems, referred to as the covered products. This notice of motion is for an interim injunction restraining the defendants from recommending, offering for sale, or selling any of their products, covered products, for a period of 5 years from 27th August 1985. So, my lord, here, my lord, there is a role reversal. The foreign company is trying to seek enforcement of an agreement, which I'll show was entered outside in India, and wanting certain injunctive reliefs. Now, my lord, straight away kindly come to paragraph 6. The defendant urged 3 points. The negative covenant embodied in clause 13 of the contract sought to be enforced by the injunction is in restraint of trade and therefore void under section 27 of the Contract Act. The plaintiff is a German company incorporated under laws of Germany. By virtue of clause 20, the contract is no doubt governed by German laws. The creation and validity of the contract is governed by German laws, but its performance has to take place in India. The performance of contract is illegal as it offends section 27 of the Indian Contract Act. Having regard to the rules of conflict of laws, the negative covenant, even if valid under German laws, cannot be enforced in India as it is opposed to section 27 of the Contract Act and public policy of Indian law manifested by section 27 of Contract Act. Then, my lord, the third contention was the contract on which the suit is based was entered into with an individual named Ludwig Taprogue. The suit is filed by, but this is a technical plea.
Section 27.
Well, next, my lord, kindly straight away come to paragraph 22. So, well, here is the role reversal. The German company is trying to enforce a contract entered in Germany to be interpreted by German law in India, where there is a negative covenant not to do certain things, which the nature of the covenant is such that under Indian laws, it is not enforced. Our violation of section 27, para 22. The principle that emerges is that a contract valid by the proper law cannot be enforced in the country where it has to be performed if its performance would be opposed to the fundamental principles of public policy or a statute of that country. It is a general principle of conflict of laws that the courts of a country will not apply any foreign law if and insofar as its application would lead to results contrary to the fundamental principles of public policy of the lex fori. In applying the principles stated above, it is of the essence of the matter that there should be a conflict between foreign law and its enforcement in the country where it has to be performed. In other words, the foreign law must conflict with a part of the lex loci solution is. What is relevant is not the character of the foreign contract in the abstract, but the result of its enforcement in the concrete cases. The rule which applies to contracts opposed to fundamental principles of public policy also applies to contracts the performance of which is forbidden by statutory law. For example, if the contract has to be performed in India, Indian statute will govern the legality of the performance. Thus, if the rules established by English courts are followed in India, Indian courts will not enforce the proper law of a contract if its making or performance involves the violation of an act of the legislature. In a nutshell, the rule is that a contract, whether lawful by its proper law or not, is invalid insofar as its performance is unlawful by lex loci solutions. The conflict of laws principles enunciated by Dicey and Morris have been affirmed by Cheshire and North also. Then, my lord, these are, my lord, the literature, my lord. I need not trouble your lordship on the private law jurisprudence, international law jurisprudence. Kindly straight away come to paragraph 29. It is therefore clear that negative covenant embodied in clause 13.1 of the contract between the parties to the suit, even if it is valid under German law, cannot be enforced in India. For this reason also, the plaintiff cannot be granted the injunction that has been prayed for. The contract with the defendant was entered into by individual Ludwig. Suit is instituted by the company. This is additional order. But my lord, para 29 is the one. Now, my lord, in this, there is reference to.
This is paragraph 25.
My lord, kindly come back once to paragraph 25. My lord, the principle what has been discussed here. Yes. My lord, the lordship will come back, not 25, my lord, para 24. The lordship will find para 24, international breach of a foreign law and its effect on validity of the performance of contract were considered by English court. Then, my lord, the first case that has been referred to is Recusal versus Casey Setia. My lord, 1958 appeal cases directly involved breach of Indian law. My lord, I just for the sake of completion want to separately rely upon this case of Recusal, which, my lord, I have got the appeal cases page is now not.
That's at page 511 and internal page 22.
Let kindly come to. Well, we have handed over the
Division.
Queen's Bench Division reports, my lord. Appeal cases, my lord, it starts at 490. My lord, straight away kindly come to page 511. I want to show a paragraph from the judgment of Lord Justice Denning. Lordship has that, my lord. Page 511, Lordship will find the last paragraph, my lord.
Yes.
Lord Justice Denning. The Union of South Africa is a country with a tremendous problem. Some say an insoluble problem in regard to the races in a midst. Her attempts at a solution met with the disapproval of the government of India. To mark its disapproval, the government of India in 1946 put an embargo on the shipment of goods from India to South Africa. This embargo hit hard the trade in jute, particularly in jute sacks, known as trade as beetwills. India was practically the only supplier of those sacks at that time, and South Africa was a large consumer of them and needed them for bagging her maize crop. In order to overcome the embargo, South Africa was prepared to pay very high price for these sacks, and there were a number of middlemen ready to help her by one means or another, so long as the money reward was tempting enough. This case is a dispute between two of those middlemen. Then, my lord, lordship will come to 513. The second paragraph. Both parties agree that the proper law of contract is English law. It is said that the contract is unenforceable because there was an intention to break the Indian law in the matter. The Indian law was enacted on 17 July 1946 before India became independent. A regulation was made under the Sea Customs Act 1878 by which the government of India prohibited the taking by sea or by land out of British India of goods from whatever place arriving, which are destined for any port or place in the Union of South Africa, or in respect of which the Chief Customs Officer is satisfied that the goods, although destined for a port or place outside the Union of South Africa, are intended to be taken to the Union of South Africa. Upon the true construction of the regulation, I think it prohibits shipment out of India either directly to South Africa or indirectly to South Africa, whenever South Africa is the ultimate destination of the goods. Then may Lord kindly straight away come to 515. Lord, in the last paragraph, which starts with Mr. Lawson, Lordship has that, 515.
Yes.
Mr. Lawson urged us to hold this legislation by the government of India was an act of retaliation directed against South Africa, an economic sanction imposed because of the racial policy of South Africa, a political law of which he says the court should take no notice. He referred us to the observations of Lord Mansfield in HON'BLE versus Johnson, where he says no country ever takes notice of the revenue laws of another. Mr. Lawson says that that has been applied to penal laws and should be extended also to political laws. It seems to me that Lord Mansfield goes too far when he says these courts will take no notice of such laws. It is perfectly true that courts of this country will not enforce the revenue law or the criminal law of another country at the suit of that other country, either directly or indirectly. These courts do not sit to collect taxes for another country or to inflict punishment for it, and this is so even between countries of the Commonwealth, as the House of Lords held in Government of India versus Taylor. These courts will not enforce such law at the instance of a foreign country. It is quite another matter to say we will take no notice of them. It seems to me that we should take notice of the laws of a friendly country, even if they are revenue laws or penal laws or political laws, however they may be described, at least to this extent, that if two people knowingly agree together to break the laws of a friendly country, or to procure someone else to break them, or to assist in doing of it, then they cannot ask this court to give its aid to the enforcement of their agreement. And then, my lord, what has been the next para, in Foster versus Driscoll, people tried to smuggle whiskey into United States in breach of prohibition laws. They were not allowed to come to these courts for assistance to settle their differences. So too these middlemen were engaged in trying to break the export laws of India, must settle their differences between themselves as best they may. They cannot come to our courts for assistance. I would therefore dismiss the appeal. So, my lord, English court recognizes that it may not be prohibitive of the English law. Principle 2, well established that they are not concerned with the revenue laws or criminal laws of another country. So it may well be in breach of FEMA or FERA or Income Tax Act. English courts may not be considered with that. But beloved, the principle is that you will nonetheless take judicial notice and you would not give an interpretation which amounts to breaking the law of another country. Now, well, this was also relied in that Bombay decision, well, to come to the conclusion that it did. Now, well, that being the position, well, I come to the next limb of the argument which was made by the petitioner, that, well, at best, there can be a violation of income tax law, and that my clients, the plaintiff in the suit, would be liable to pay, let us say, a penalty or monetary consequences there, that they would be charged at a rate of, on a value, it would be a capital gain, which we of a much higher value. That is none of our concern. That may be one aspect. Second, it may be a compoundable offense under FEMA, and therefore it's a question of a monetary relief, and it is of no concern. My lord, I want to show your lordship, my lord, violation of Rule 16 is not a compoundable offense. My lord, for that, my lord, I rely upon the RBI circular or directions dated 1st October 2024 Lordship would see, my lord, at the very first paragraph, compounding. The provisions of section 15 of FEMA enable compounding of contraventions and empowers Reserve Bank to compound any contravention as defined under section 13 of the FEMA, except contraventions under 3A of FEMA on an application made by the person committing such contravention. Government of India, with a notification dated so-and-so, has notified the foreign exchange compounding proceeding rules in supersession of foreign exchange compounding proceeding rules 2000. Now, Lordship will kindly come to the guidelines, which Lordship will find starts the index it at the 3rd page. Well, at the guidelines, and in that, well, kindly come to clause 2 first, guideline number 2 first, which is, well, it should be, well, page 2 of this compilation, where the pagination is at the bottom. Well, at page 2 of the printed page 2, it should be technically, well, at the 4th page. Compounding of the contraventions by the Reserve Bank. In order to facilitate operational convenience, contraventions of following rules or regulations issued under the Act shall be compounded by compounding authorities of the Reserve Bank at regional offices. Now, my lord, a tabulation has been given. In the tabulation, Lordship will kindly come to, my lord, clause 2.2, which is in internal page 4. My lord, the pagination is at the bottom. Lordship will find page 4. Yes. And in internal page 4 under 2.2, Lordship will find the contravention of rules and or regulations relating to liaison branch project office non-resident foreign account and immovable property shall be compounded by compounding authorities of the Reserve Bank attached to FED cell at New Delhi office. Then, my lord, the FEMA notification have been quoted. Lordship will find what has been quoted is, what is compoundable is Rule 21 of the Foreign Exchange Management Rules. I'll show, my lord, what is Rule 21, because, my lord, our case is under Rule 16, which I have showed your Lordship, Rule 16. Now, Rule 21 is compoundable. I'll come to that. But, my lord, before that, kindly also take, my lord, clause 4.4. I'm sorry, 4.2, which is at internal page 6. No compounding application shall be processed unless the requisite administration action is completed by the applicant. And in the explanation, Lordship will find administrative action shall mean such action as may be necessary with respect to transactions involved in such contravention and shall include such corrective action that shall be undertaken by the applicant to bring transactions involved in contravention in compliance with applicable provisions of FEMA. An indicative but not exhaustive list of such administrative actions include, and Lordship will find Roman 3 and Roman 4, repatriating the receivable dues, and 4, compliance with pricing guidelines or submission of valuation certificate. So, repatriating the receivable dues is equivalent to Regulation 9, which I showed your Lordship. And, my lord, 4 is, my lord, that clause 16. My lord, the pricing guidelines. Lordship will see clause 16. Clause 16 ta kothay dekha jay. Sorry, Rule 16, not clause 16. My lord, Lordship opens, my lord, the 2020 rules. 2022 rules, my lord, Lordship will see, my lord, Rule 16. There are two relevant considerations of 2022. One is the regulation, one is the rules. I am now on Rule 16, which is the pricing guidelines, where, my lord, that expression arm's length basis is there.
Yes.
So unless otherwise I had placed it on the last day. I'm just for the sake of completion, just repeating it. Unless otherwise provided in these rules, the issue or transfer of equity capital of a foreign entity from a person resident outside India or a person resident in India to a person resident in India who is eligible to make such investment, or a person resident in India to a person resident outside India shall be subject to a price arrived on an arm's length basis. The AD bank, before facilitating a transaction, shall ensure compliance with arm's length pricing, taking into consideration the valuation as per any internationally accepted pricing methodology of valuation. And I have already shown, my lord, that email, my lord, how the AD bank had, my lord, triggered, my lord, the dispute, whatever it is, my lord, I had placed that email. So, my lord, this lordship will read it as, my lord, clause 4, with clause 4 of risk, compliance with pricing guidelines or submission of valuation certificate, and repatriating that 90-day clause, my lord, that is, it should be read with, my lord, clause 3. With clause 3. So, my lord, this takes care of
clause 3 of what?
I'm sorry, my lord. Clause 3 of the regulations, 4.2,
Clause 3 of the regulation.
4.2 of the directions. I'm sorry.
Yes.
Directions of 1st October 2024. 4.2, I had relied upon clause 3 and clause 4. So 4.2 clause 3 is to be read with, my lord, regulation 9.
Regulation 9.
With regulation 9. And, my lord, 4.2 clause 4.
16.
Rule 16. So, my lord, this takes care of the second limb of the argument of the petitioner, that whether even assuming there is a violation of FEMA or any other Indian law, whether it can be regularized upon payment of penalty or late submission fee or any other monetary component, because it may be a compoundable offense or whatever. Then, my lord, the third limb of the argument of the petitioner was that whether a relief can be granted by the first appellate court, which was not directly prayed for in the court below, or the first or the trial court. Now, my lord, in this, I will not, my lord, trouble your lordship by showing the reliefs again. Lordship, my lord, has already been shown the reliefs in the plaint, that declaratory relief, the mandatory injunction in support or a consequential to the declaratory relief. I have already made my submission. Now, my lord, I want to show what was the relief in the injunction petition before the trial court. My lord, kindly takes page 143 of CO 4439, which should be in volume 1.
Four, 4.3.
Yes, my lord, the prayers start at page 143 in volume 1. But I would beseech your lordship to come to page 145, prayer E. An order for temporary mandatory injunction directing the respondents stroke defendants and or men, agents or servants and or assigns and or heirs, successor in interest, successor in office, by directing them to sell the shares of the petitioner at a reserve price as pleaded herein above, or as may be determined by the learned court, and thereafter to transfer the amount to the petitioner or plaintiff forthwith. So, my lord, indirectly, it is also, my lord, trying to comply with what was that agreement. But it is only, my lord, it is couched in a different fashion that you determine the fair price or arm's length price or whatever, whichever term you may put it, and then you transfer it here so that it is not in violation of Indian law. The performance part of it is being regulated so far as this is concerned, so that it is in line with what Indian law is. And my lord, Lordship has already seen, my lord, what was the relief in the suit claim, that the agreement as it stands is void because of these reasons, and my lord, mandatory injunction if it is void. And now Lordship will see what is the prayer in the first appellate court, page 211 of volume 2. So, my lord, before the trial court and all, my lord, in my respectful submission, my lord, whichever way it is couched, my lord, it is in aid of the final relief. In the first court, my lord, it was couched that he should not buy it back. On the contrary, my lord, the relief was that I will sell it at, my lord, in accordance with the reserve price or in accordance with, my lord, pricing guidelines of Indian law because of the FEMA violations. This is what was prayed before the court, first court. Now, Lordship sees what was there in the appellate court, which was allowed. Order of temporary injunction restraining respondent, defendants, main agent, so-and-so, successors, the interest, office, director, shareholders, other person in association with and or in connection with pro forma defendant from taking any steps to sell or from selling any shares, having number of the plaintiffs in favor, having number so-and-so of the plaintiffs in favor of the respondent without leave of the learned court. So essentially, it's in aid of the same relief. One is couched in an injunction this way, the other is couched in an injunction so that they may be restricted. And my lord, in my respectful submission, none of these two reliefs are, my lord, outside the purview of the main relief. Because, my lord, what is my second relief B is decree for declaration, which is at page 97 of volume 1. Lordship will make a note, the reliefs start at page 97 of volume 1. Decree for declaration that the shareholding agreement is void ab initio, nullity since its inception, as against it is against public policy, no binding effect, not enforceable. And decree for declaration that articles of association in so far it violates the provisions of Indian law, but not limited to income tax and FEMA, is void ab initio. And well, whichever reliefs Lordship look at it, my respectful submission is I am entitled to ask both these reliefs in support of my final relief, or both these prayers in an interlocutory application in support of my final relief in relief B and relief C. That is to the extent, because, my lord, the violation or mischief or problem is arising only at the time of repatriation, and the value is becoming important because of repatriation. If I could have parked it in London, perhaps, my lord, what the petitioner is saying could have been. But, my lord, it is, I cannot park it in London, I have to repatriate it in 90 days. And, my lord, there will be a violation so far as, my lord, pricing guidelines are concerned. Pricing guidelines is on arm's length basis or arm's length. And, my lord, in the Income Tax Act, my lord, Companies Act, it's on a different parameter. Lordship will find there is a definition. I'll just give you a Lordship. Well, the last limb of the petitioner's argument was that I'll just cite the provision, the section. Yes. Well, this is section 92F. 92 capital F of the Income Tax Act. My lord, this is of course from another statute. My lord, and I am conscious of the principle that, my lord, arm's length in a particular statute, my lord, may not be a definition. I am just trying to give your lordship an idea as to what it is, because, my lord, subject to correction by Mr. Mukherjee, my lord, I could not find any definition, my lord, so far as the FEMA is concerned. So I have tried, my lord, the closest here. Arm's length.
It's for price. I will know it.
Let's section 92F, clause Roman 2. Arm's length price means a price which is applied or proposed to be applied in a transaction between persons other than associated enterprise in uncontrolled conditions. And in a contract, the terms and conditions of buyback at the issued price, it's a controlled condition or agreement between the parties, whichever way lordship looks at it, it's under controlled conditions. Now, so far as the last leg of submission is, order is perverse and without reasons. This is, the last limb of the submissions on behalf of the petitioner. Now, kindly see the order in question. Lordship has seen the order which was passed by the trial court. The first and against that order, a first revisional application is filed. Because that revision was pending, at the second instance, when the petitioner here and the defendant in the suit appears, and they raise this question of territorial jurisdiction, or rather forum selection clause, the reasoning of the first appellate court is that it is, I have already held good, bad, indifferent in the previous order, that 18th November order, I have held this court has jurisdiction, I have passed an order. Now, you have challenged that in the first civil revisional application, which is CO 4439. That is CO 4439 against the order of.
I am hearing 4439 only.
Yes, that is the order of 18 November, from the order of 18 November. And there is another CO from the order of.
Extensions.
No,
that is
one is the order of 18th November, then is the order of 18 December, and then comes, my lord, the other COs, which are the order gets extended from time to time.
18 December is a different order. What is not an extension?
Well, first order, which is the subject matter of CO 4439,
because
that is ex parte ad interim. Because, my lord, one limb of my learned friend's submission was that after I come and point out to the court that there is a forum selection clause, and, my lord, the jurisdictional issue was pointed out, that should have been dealt with, and without dealing with that, you couldn't have proceeded. So I am trying to just show that so far as the first order is concerned, it was ex parte ad interim. It has proceeded on the premise of what earlier was. I dealt with the point that the relief was couched in a different way, which has been granted.
CO tag to the 224.
Well, the second CO is CO 224 of 2026. CO 224. Two 224. But in the meantime, I can read the order, so lordship will have that. 18 December order is order number 4. 18 December. What is the subject matter of the previous one is 18th November.
18 November is before me.
18 November, lordship has seen.
Page 59.
One is 18 November, the other, order number 4 is 18 December, which is subject matter of CO 224. At page 59, lordship will find that. CO 224, page 59.
Respondent petition.
Because, my lord, this is the first time, my lord, the court takes notice of what the respondents have stated. My lord, I read from the fourth line. Respondents filed, Lordship has found that, my lord, order number 4. Dated 18 December 2025.
18 December. Which is the volume in which that is there? Volume 1.
Volume 1, my lord.
Volume 1, page 59.
Page
Volume 1, page 59.
Page 59, yes.
Yes.
18 December.
Yes. Well, I read from the fourth line. The respondents filed a petition on the ground stated therein raising objection on the territorial jurisdiction of the Indian court, primarily relying on the agreement as entered into by and between the parties to the dispute, that any dispute or claim arising out of the agreement shall be governed by and construed in accordance with English law, and exclusive jurisdiction of the courts would be of England and Wales. Outcome of which the court in UK passed an order on 2nd December 2025, which is forced till 16 January with specific direction that, my lord, defendant shall be restrained until a further order from pursuing. This is the anti-suit injunction, my lord. What is there? This has been noted, A and B. Well, kindly come to the last paragraph. Learned counsel appearing for the appellate by filing a Firisti submits that challenging the order of this court as passed by the judge in charge on 18 November 2025. The contesting respondent had filed a civil revisional application under CO 4439 of 2025. The learned counsel further submits that the agreement itself is under challenge before the learned trial court in the suit, and the matter being sub judice, the order of the court in UK has no binding effect in the Indian law, as the jurisdiction of courts in UK and the order itself have been passed ignoring all relevant consideration, and such a hybrid legal system fails for any applicability here. Peruse the order of 18 November as passed by the learned district judge in charge, by virtue of which the respondent and its men and agents are restrained from taking any step to sell any shares having number 1 lakh of the plaintiff appellant in favor of the respondent defendant number 2 without the leave of this court till 18 December 2025. Upon hearing both sides and on appreciation of the appearing circumstance, especially the fact that the ad interim order of 18 November as passed by the learned judge in charge of this court has been placed under challenge before the High Court in Calcutta in CO 4439, the matter being sub judice, this court is of the prima facie view that passing any order pending challenge before the Honorable High Court is contrary to the principles of judicial propriety and comity, and when the matter is pending before the High Court at Calcutta, this court should restrain and avoid passing order that could circumvent, prejudice or render infructuous the proceeding. It has also been settled by honorable courts that once an appeal is filed, the decision loses its character of finality, and what was once res judicata again becomes res sub judice, that is a matter under judicial inquiry. Therefore, at this juncture, this court is of the opinion that when a revisional application has been filed against the order of this court before the Honorable High Court, the same issue becomes a pending matter. Accordingly, this court, as on this day, strictly avoids to set aside the order which is already under challenge before the Honorable Court, as per prayer of the respondent, that the civil court in India has no territorial jurisdiction to try the case on the basis of contractual obligation between the parties to the suit, and the order from court in UK is binding upon the party to the suit or appeal. However, on the basis of ongoing dispute between the parties and pending adjudication by Honorable Court, the ad interim order of 18 November be extended till the next day. So, my lord, this is a plausible view which has been taken, because, my lord, if in 4439, my lord, it goes, everything will automatically fall like a pack of cards. And that is why, my lord, I was trying to, my lord, concentrate my efforts so far as, my lord, the 18 November 2025 order is concerned. Now, my lord, the last leg of the submission was, my lord, effect of an anti-suit injunction by, my lord, an English court. Now, my lord, in this context, my lord, Lordship will just make a note. The relevant provision of, or the relevant jurisdiction of the English court, my lord, it has to be, my lord, in terms of clause 22(2) at page 80. I'm sorry, my lord, the page, thick page ta bolo.
It is 307 of it.
307. It should be at 307 of volume 3. volume 3 of 4439. And a typed copy is also there. Clause 22.2, I just read it again, my lord. Each party irrevocably agrees Court of England and Wales shall have exclusive jurisdiction to hear and determine any suit, action or proceeding and to settle any dispute or claim, including non-contractual dispute or claims which may arise out of in connection with this agreement. Its subject matter or formation or any documents entered into in accordance with its provision, or as to rights and liabilities of shareholder in connection with their business and their holding of shares, and for such purpose irrevocably submits to exclusive jurisdiction of such. Whether the performance is valid in courts in India is not falling in my respectful submission within the four corners of clause 22.2.
Can I go and seek this declaration in English court?
Because, my lord, I cannot get this declaration in English court. That is my first limb of my argument. So if that cannot be, my lord, the jurisdiction to give an anti-suit injunction on which, my lord, the English court will not have any jurisdiction, my lord, in my respectful submission does not arise. And assuming, my lord, it can, my lord, in terms of that Queen's Bench decision, my lord, the appeal cases, my lord, the English court should have, on the contrary, my lord, taken notice of, my lord, the relevant revenue laws in India, my lord, as per that ratio of that judgment. And, my lord, if, my lord, I am correct in my submission that if it cannot be enforced, the performance aspect or part of it cannot be done, my lord, the anti-suit injunction also, my lord, it doesn't alter the situation, or so far as my lord is concerned, it does not require any interference so far as these two orders are concerned. And, my lord, all this, my lord, I have shown a prima facie case. I'll elaborate it further on merits, my lord, if I get a chance. But, my lord, lordship will kindly bear in mind, the last leg of my submission is, what will be the effect if the order is vacated today? The effect would be that, my lord, they would put the money in a trust. Shares would be brought back by the company, which is, of course, in England. And, my lord, the money, the trust would be holding the money for, my lord, the plaintiff in the suit, for the benefit of the plaintiff in the suit. And, my lord, under the Indian law, I have to repatriate it in 90 days. And I will be hauled up for FEMA. Because, my lord, this is not a compoundable offense.
Contravention.
Compoundable, not offense, contravention. No amount of money will, my lord, monetary penalty will not, my lord, let me off. So, my lord, there is no scope of regularization which was submitted. My lord, that being the position in my respectful submission, my lord, the suit is well framed under the Indian law. The English court will not have the jurisdiction to do it. The forum selection clause, therefore, my lord, will not have any impact. And, my lord, the interlocutory reliefs is well within the parameters of the suit. And, my lord, a prima facie case existing in this situation, my lord, lordship would be pleased not. Those are my. Can I take my lord's leave?
Yes, yes.
But actually, because I had promised your lordship, I'll conclude it today. But because of 3:30, my lord, both of us have an arbitration.
Yes, yes. My lord, I'll be very brief. My lord, I didn't have to, my lord. My learned friend has argued matters, my lord, which, my lord, I have not even argued. But, my lord, first most important thing, there has been no suit anywhere in England seeking, my lord, my lord, decree, my lord, for, my lord, specific performance, my lord, of the contract. My lord, the only suit which has been filed is there is a forum selection clause, governing law clause, and the suit which has been filed in India is in derogation of that clause, so you grant an anti-suit injunction. That is the only thing. Kindly remember this. Whether, my lord, there's violation of FEMA, FERA, or, my lord, whether Income Tax Act, etc., my lord, none of them are, my lord, an issue there. But, my lord, but kindly keep that in mind.
That suit has been instituted by your client.
Yes, because I'm saying he is acting contrary to the governing law and jurisdiction clause. In fact, the jurisdiction clause by going there. I cited Modi, my lord, which recognizes, my lord, such clauses. Because your lordship knows, my lord, in India, if it doesn't have jurisdiction, if you have a jurisdiction clause, that is wholly odious. You can't have somebody in a court in India which doesn't have jurisdiction. But as far as foreign jurisdiction is concerned, it's permitted. I read that passage, my lord, in Modi, which has not been dealt with. Now, my lord, but I'm coming one by one. My lord, first, my lord, the principal point I argued, my lord, was about, my lord, the maintainability of the appeal, which has not, my lord, before the district judge, which has not been dealt with at all. My respectful submission to your lordship was that, my lord, there had been a postponement of the decision in respect of the other prayers by the learned judge. Postponement, my lord, is not, my lord, an order, my lord, which can, my lord, be appealed. I cited Samsel, my lord, Supreme Court. There was no decision on these issues. So the appeal could not have, ought not to have been entertained at all. And, my lord, we are in revision. My lord, if there was a jurisdictional error, my lord, that's when we started out, my lord, with, my lord, CPC and revision. And now, my lord, in 220, that principle still applies. My lord, it's a jurisdictional error, my lord, which was made. So, my lord, I had, my lord, cited, my lord, Samsel. This is not being dealt with, not answered at all. My lord, on that ground itself, my lord, all the orders have to go. Now, my lord, the second thing, what did I, my lord, argue? My lord, my argument was, my lord, that, my lord, the issue here is of territorial jurisdiction as well. Now, my lord, why do I say so? Lordship seen, my lord, the governing clause, the law which will govern, and your lordship has seen, my lord, the forum selection clause, which is, my lord, UK courts. Now, my lord, in UK courts have jurisdiction. My lord, there is not one adjudication, my lord, which has been made. I had cited, my lord, the the Asma Latif's case, my lord, that, my lord, jurisdiction, yes. Otherwise, my lord, that has not been. My lord, unless nowhere, my lord, has it been said, my lord, that was decided or a prima facie view was taken on that. In fact, the second extension which was granted, when I raise it, they say, oh, this issues before the High Court, we won't touch it, and extend it. That extension itself is bad on that ground. My lord, I'm not going to cite the cases I've cited already, my lord. Now, my lord, Modi, your lordship remembers. Now, kindly have a look at, my lord, the case which my learned friend cited. My lord, Goel gases. My lord, I had appeared in this. My lord, kindly, my lord, come to my lord, para 54, para 55, and my lord, all the paragraphs that my learned friend read and which he did not read, my lord, which was para, my lord, 85. My lord, today, my lord, he cited, my lord, I'll give your lordship the reference, 2026 SCC online SC 648.
Yes.
Lordship has that. Now, my lord, this was a case to start with under section 13 of the Code of Civil Procedure. So, my lord, there has to be a decree, my lord, of a foreign court, which I am seeking to enforce. the greatest of respect, I am not seeking to, my lord, enforce a decree of a foreign court here at all. There is no decree which I am seeking to enforce. So, my lord, case is wholly inapplicable. Now, my lord, kindly have a look
No,
at.
his argument was that even if a suit was filed in
My
English,
lord, let's not, yes, well,
and if a decree was obtained, it
yes,
would have been
by ignoring Indian law. It had to be established that it was, so my lord, the English court
says that since it sort of contravenes FEMA and the
so English court could not have passed a decree. My lord, the decision will be taken by the English court as per forum selection. Question is the English court competent? Modi says it's competent. Question is, my lord, can, my lord, English court apply Indian law? Yes, it can. My learned friend cited, my lord, that decision of Setia. My lord, Lord Denning's judgment is giving effect to Indian law. And my lord, I must tell my learned friend, this matter also went to the House of Lords. I'll give this, and it was affirmed. For completeness sake, my lord, we stopped at Court of Appeal. Queen's Bench, which was cited, I told my learned friend, this went up to the House of Lords as well. The reference for them?
1968 appeal case.
Yes, my lord, it's 1958 appeal cases. 301. My lord, that's the House of Lords. It was affirmed. Now, my lord, what happened? My lord, this very case which my learned friend cited, my lord, English courts had passed a decree. My lord, question was whether it was also competent to do it. My lord, your lordship has been shown issue 2, whether the judgment is unenforceable in view of conditions imposed by RBI in exercise of statutory power under FEMA. Now, my lord, kindly come to, in view of our decision on the first issue, it is not necessary for us to delve. Now, what was the first issue? My lord, under well-established procedures, if your lordship takes section 13, my lord, kindly have a look at section 13 of the code.
Yes.
My lord, kindly take, my lord, a foreign judgment shall be conclusive. There's, as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them claim litigating under the same title, except, my lord, kindly note, where it has not been pronounced by a court of competent jurisdiction. B, where it has not been given on the merits of the case. C, where it appears on the face of the proceedings to be founded on an incorrect view of international law. Now, kindly note this. Or a refusal to recognize the law of India in cases in which such law is applicable, and where the proceedings in which the judgment was obtained are opposed to natural justice, where it has been obtained by fraud, where it sustains a claim. Kindly note this. Where it sustains a claim which is founded on any breach of any law in force in India. So the claim itself is barred by reason of, my lord, a law in India, and yet it sustains that claim. So, my lord, if he were a plaintiff and he's founding a claim on Indian law and is not barred by Indian law, his suit would lie. Now, my lord, let's not preempt, my lord, what the English courts would have decided. But, my lord, sanctity of contract, my lord, is important. Now, in this issue, my lord, kindly see the first issue which was, my lord, decided, my lord, in this case. If your lordship kindly turns to, and then I'll come straight away to those paragraphs and show your lordship, my lord, the court held that, my lord, the English courts were competent here. My lord, kindly take the first issue, page 10.
Page 10, bracket 7.
Yes. Kindly come to, my lord,
Issues for consideration.
on the basis of submissions advanced. My lord, para 28, my lord, print page 10.
Yes.
My lord, whether the judgment is in consonance with requirements of 13, read with 44A. Now, my lord, the agreement, etc., all, my lord, set out. my lord, order 37 of ours, my lord, all that. My lord, kindly come to para 41 first.
Yes.
We may now advert to the issue as to whether a judgment passed by a foreign court in a summary manner by refusing grant of leave to defend can be regarded as having been rendered on the merits. That is B, my lord, the ground B in, my lord, section 13. Now, my lord, where, my lord, it has not been given on the merits of the case. Now, my lord, this is, my lord, para 42 now. Therefore, when the dispute before the court is demonstrative of the fact that highly compelled deeper scrutiny, disposal of the case in summary jurisdiction would cause grave prejudice to the party seeking leave to defend, not only in India, even under the principle is followed, and civil procedure specifies so and so. Principles adhered to has been crystallized in so and so. Then, my lord, kindly come to para 44, when leave to defend should have been given. Then, my lord, para 46, kindly see. Respondents, defendants involved proof of oral agreements, required detailed examination. There are contemporaneous documentary material, my lord, which is. So, my lord, it was, my lord, decision, my lord, which was passed without, my lord, going into, my lord, all, my lord, the matters. In our, then para 52 is what is very, very important. In our considered view, triable issues were disclosed, respondents sought leave to defend, adduce so and so, it was incumbent on the English court to refrain from, by way of summary, grant of summary result in premature adjudication and defying the meaningful opportunity to having aware of the procedure adopted, so is not consistent with well-established principles. Miller, natural justice runs through, Miller, any legal system. So, Miller, it was no need to decide. Now, Miller, whether judgment is unenforceable in view of conditions imposed by RBI in exercise of statutory power. Under, kindly mark this, Miller, under FEMA. It's not FEMA. Vijay Karya is cited, specifically distinguishes FEMA and FEMA. This is a FEMA case. Now, Miller, kindly come to para 55. What was, Miller, Mr. Chidambaram's submissions? There is no dispute about the fact that the mandatory requirement of obtaining prior permission of Government of India as well as that of RBI was secured by the parties, was secured before availing external borrowing. However, the question relates to the consequence of conditions imposed by RBI while granting permission by its letter dated so and so. In other words, whether the condition that in case of invocation of guarantee, no liability whatsoever will extend to the Indian company would operate as an absolute bar to enforcement for all times to come as contended. So, my lord, it's breach of a condition of, my lord, permission. Now, kindly have a look, my lord, at para 83. My lord, after the discussion, at page, my lord, print page 37. In view of the above discussion, we have no hesitation in rejecting Mr. Chidambaram's submission that there is absolute and total bar of enforcement of a decree by virtue of the conditional permission. This submission is therefore rejected. In the normal course, a party obtaining foreign can seek, if such a qualifies the test laid down, central government RBI can exercise its regulatory power under 47(3) and grant its approval before any further steps are taken. Doesn't render it void. I can come and seek enforcement. The argument is rejected. Now, my lord, kindly look at para 85. This is, my lord, very, very crucial. At this juncture, it would also be apposite to clarify that the objections raised by the respondent do not extend to all the grounds enumerated under section 13 of CPC. Upon careful consideration, we find that the English court possessed jurisdiction over the parties and the subject matter. The loan agreement executed between the parties expressly provided that the contract would be governed by English law and the disputes arising therefrom would be subject to the jurisdiction of the English courts. A reading of clause 12.5, 31.1 and 31.2 leads to inescapable conclusion that English court was a competent court. Likewise, no case of fraud, etc. To that extent, judgment cannot be faulted. So if it was a competent court, 13A, my lord, your lordship sees clause A, my lord, of section 13. It's competent court. Was English court the competent court? Yes, it was. So, my lord, number one, my lord, jurisdiction, my lord, to entertain the appeal was not there. Second, my lord, is, my lord, the foreign jurisdiction clause. Contract says, and I cited Vodafone. Why? English company. Shares, my lord, Citus is England. Performance happens there. Now, my lord, no. So, my lord, the first 4 points, my lord, have actually not been dealt with at all. Jurisdiction to entertain the appeal. 2, my lord, the, my lord, determine, my lord, prima facie that it has jurisdiction. Third, my lord, that an extra, if I was wrong on the first, he had jurisdiction, my lord, to entertain the appeal. Second, my lord, whether Indian courts had jurisdiction, needed to prima facie determine. And third, my lord, recognize this as an extraordinary situation that he had to do this. My lord, they are saying, my lord, urgency was, I would have bought the shares back. So where is the performance? It's there. And the citers of the shares, my lord, are, my lord, in, my lord, bad lever, etc. I'm not going into all that. Now, my lord, order, my lord, without reason. First order. Second order, my lord, not deciding jurisdiction is, my lord, without reason. But the rest is, my lord, because of pendency. No bar. And, my lord, second, my lord, in any view, otherwise extending. Extension is continues to be without reason because the first order was without reason. These are what I had argued. My lord, Mr. Roy had, my lord, started on FEMA, which is why, my lord, I had pointed out, my lord, those provisions. Now, my lord, I can deal with them. According to me, my lord, it's really not necessary because the English court has not decided these issues. Nobody is seeking enforcement, my lord, of a English court decree here. All that I'm saying is the courts here would not have. Now, my lord, my learned friend has cited 87 SCC online Bombay. My lord, that is restraint of trade, my lord. My lord, what did I submit before your lordship? My lord, when I showed your lordship, my lord, the order of the first court, I said I didn't challenge it. There was a restraint of trade for 6 months. My lord, he could not, there's a non-compete clause, my lord, for 6 months under the contract. 6 months was over in March. And I said I have not challenged that portion. I'm only challenging the district judge's order when he entertains the appeal and passes an order which was not even prayed for. My lord, I must appreciate my learned friends, my lord, linguistic semantics in saying the prayers are one and the same. It's not, because one is not an injunction. One is you allow the sale, but I need a fair price for it. So the money which will be remitted, it sounds in money. And the other is a blanket.
Restraint.
Yes. So, my lord, Now, this case related to restraint of trade, my lord, it relies on, my lord, in India, my lord, we have taken the view, my lord, right up to, my lord, the last significant judgment was of bench presided over by Justice Kapadia. My lord, Golak Curry and all, my lord, were relied on, that this restraint after the termination of the contract, these were all contracts of employment, my lord, to start with. Well, I'm not going into that because I didn't want to, my lord, challenge that. My lord, he wants to work. My lord, I'll show your lordship a letter. My lord, he had written, please don't interfere with my employment in Infotech. It's on record. My lord, my learned friend cited one page. I'll just show the mail in response to which my learned friend had, my lord, written. Now, my lord, I told your lordship specifically, I'm not challenging this, I'm not challenging it. I'm only challenging the appellate court order. So, my lord, this restraint of trade has applied. My lord, the conflict of law rules. So, if they are right that, my lord, FEMA, my lord, would prevent such a transaction or the regulations would prevent, they should raise it before the English court. It's the competent court. They can't come here. Now, my lord, kindly take, he placed that paragraph. My lord, kindly just give me one moment. Now, my lord, kindly take, my lord, yes, my lord, page 391. My lord, volume 3 of the first revision, my lord, 442. 4439, sorry. 4439. Lordship has 4439, my lord.
Yes.
My lord, kindly take page 391. Yes. Now, my lord, my learned friend placed this, my lord, yesterday. One parata dekhiye chalo. Showed this letter. He showed. Yes. My lord, my learned friend had shown, my lord, page 392. My lord, the first para he had placed, my lord. You make a point in your cover letter on the authorized dealer bank regulatory block. This is a matter between the bank and the company. Kindly note this. Lordship has that. And we are working with the bank to try and resolve this, as you're well aware. While we expect this to be resolved quickly, it is beyond our direct control. In any case, this does not affect your rights in any way till kindly note this, March 2026. You are bound by the 6-month non-compete clause in so-and-so currently and not supposed to be work for a competing business till March. And we fully expect this matter to be resolved by that. So we were, my lord, facilitating, my lord, the share transaction. We were willing, my lord, to work with the authorized dealer. Now, my lord, kindly see our letter. 387. My lord, this is also 22nd October. What? Yes, their letter, not my letter, my lord, their letter. So what I read was our letter, my lord. Kindly come to, this is their letter, page 387, 22nd October 2025. Thank you for sharing the final clear draft version of the documents. I have now reviewed it with my lawyer. Kindly find enclosed the updated documents with all changes and comments made in red. To finalize the documents, there are 3 key items we need to resolve. My lord, we are looking at somebody who today comes and says the whole thing is void. You can't implement this. Kindly see what he writes. Tax liability without prejudice. My main concern is the future tax liability. As we have discussed, the buyback price is substantially below market value, and I cannot be expected to absorb a tax penalty, if any, on a gain I'm not receiving. We will need to agree on a provision for the company to cover this or to adjust the bonus payment to an equivalent amount. So, my lord, I don't want to, I'm not saying that everything is bad. I might suffer a higher tax liability under Income Tax Act. Because what should be, my lord, the consideration? My lord, there could be, my lord, a deemed, my lord, income, and therefore, my lord, that be a higher, my lord, tax liability. Then, AD Bank, that's HDFC, regulatory block. As the AD Bank has now formally communicated, they will not permit the foreign exchange transaction for this buyback. Now, my lord, why? The bank has stated this hold is due to historical FEMA non-compliance by the company regarding other employee investments. Now, my lord, I had shown this, my lord, which is at page 339, or my lord, it's at 366 of this volume. My lord, I had shown it from 339 of 224, which involved, my lord, transfer of shares from his wife to him also. It has got nothing to do with the buyback. My lord, they were saying they won't recognize the buyback. Why? Because, my lord, historically, my lord, there had been non-compliance by the company regarding other employee investments. This transaction is therefore on hold until Innoverve completes the necessary regularization process with RBI. And that's what we wrote, my lord, at page, my lord, 392, which I showed your lordship, that we are in touch with the bank, we'll remove it. Now, my lord, kindly see the 3, future employment. Since we are in agreement, kindly note this. Since we are in agreement to execute the buyback in principle, the company will not object to me in joining ITC Infotech in India or any other offer that I may receive and communicate to the company. As you understand, this is a question of my livelihood, and the regulatory block point 2 is a company level compliance issue entirely beyond my control. These 3 items are the final prerequisites for execution. I'm prepared to sign these agreements when we have a written agreement on tax liability and company has successfully resolved the regulatory. My lord, and today we are told it's violation of FEMA, it's void. See the prayers, my lord, in the plaint. This is his stand. And then how does he come? He doesn't go to England, where he ought to have gone and said, look, this is violation. They are seeking to enforce something. Don't permit this to happen. Allow it only to happen if I get this. My lord, whether, my lord, regulation 16, my lord, applies to, my lord, compulsory buybacks or not, my lord, is another issue. Because he is not, my lord, responsible for that. I have a right, my lord, in UK, in respect of shares, my lord, which are there, and I'm exercising that right. Now, my lord, kindly have, I just remind your lordships, my lord, of, my lord, Vijay Karya, my lord, which is, my lord, at, wait 1 minute. Jani, my lord, kindly take para 88. My lord, of Vijay Karya, it's 20, it's there already. Please don't multiply, please. 2011 Supreme Court cases 1.
Yes. Para 88.
Yes, now, my lord, kindly have a look at this. This reason, my lord, second sentence, my lord, 5th line. It is important to remember that section 47 of FERA no longer exists in FEMA, so that transactions that violate FEMA cannot be held to be void. Look, we are concerned with FEMA here. Then, my lord, also if a particular act violates any provision of FEMA or the rules framed thereunder, permission of Reserve Bank of India may be obtained post facto if such violation can be condoned. Then, my lord, neither the award nor the agreement being enforced by and therefore be held to be of no effect in law. This being the case, a rectifiable breach under FEMA can never be held to be. That's, my lord, the 3rd limb. But, my lord, the transaction is not void. My learned friend read out the compounding rules. My lord, it's not something which cannot be compounded. There are certain conditions which have to be met. If they are impossible to be met, or I satisfy, my lord, the authority that it cannot be met, it's the end of the matter. My lord, in Renu Sagar, my lord, it was FEMA violation. And my lord, they refused to enforce the award. My lord, here, Renu Sagar was cited. They said, sorry, that was FEMA.
Law has changed.
Yes. So, my lord, I showed your lordship the income tax provisions. They don't bar the transaction.
Only the tax slab.
Yes. My lord, it will be treated as deemed income. Now, my lord, if it's a buyback, your lordship seen the clauses. If they don't transfer, my lord, I have a right, my lord, to compel. And I compel it there. It's performed there.
His only argument was if it is brought back in India, then in that case.
You can apply to, it doesn't render it void. And you can get a direction. I have not come here, my lord, to enforce, my lord, the agreement. Which is why, my lord, these clauses are there, and particularly where, my lord, a shareholding in a foreign company is involved. My lord, by citers of the shares, Vodafone, I cited one, my lord, earlier decisions as well. The shares are there. He may hold the certificate here. His rights are there. Because what are the rights that a shareholder has? The right to vote, which has to be there. And, my lord, in England, my lord, shares are treated as, my lord, not as chattels as here, my lord, which is, my lord, movables. My learned friend talked about physical delivery, etc. There are choses in action because a bundle of rights. And your lordship seen his letter. I'm grateful, my lord, my learned friend, my lord, cited it. My lord, if your lordships want a short note, I can give it to your lordships tomorrow. But, my lord, I think we can, my lord, conclude today.
Both parties can give if they want. If they don't also, I have my own.
Yes, I know, my lord. That's why, my lord, I'll try. My lord, I want to look at it. But, my lord, I don't want to make it more than 3 pages.
It's open for both the parties. If you can, you give. Even if you don't give, I have my own notes.
Yes, yes. My lord, my lord, just wanted to remind your lordship about Samsel.
Yes.
My lord, because there's no answer to that.
Remind him if he wants to answer and come and answer tomorrow.
Very well, my lord. I shall convey.
But tell Mr. Mukherjee, it's just
very well, my lord.
Yes, my lord, your lordship gave us, my lord, liberty, my lord, to file a supplementary affidavit, my lord, rather than a petition with regard to the last extension, my lord. Yes. My lord, may we file that?
Before rise.
Just a moment. I'm yet to conclude.
My lord, that has the last extension. Challenge karo so thoda.
And the item 182 also has to be tagged with the.
My lord, item 182 also needs to be tagged with this, my lord. That's another extension order which has been challenged.
182. Today's list.
Yes.
In today's list.
This is in CO 1513 of 2026. Which is that?
Which is item 182.
My lord, in 182, by way of supplementary affidavit, we've challenged that.
182.
I'll get list.
182 তাই অর্ডারটা রেকর্ড করুন। Mr.
last few days, there's some urgency. There's direction for maintenance.
Maintenance direction after.
I have a good case on merit.
Yes.
10th is the date for execution. That's the whole difficulty.
10th is the date. I'll take it on 8th.
Can you fix the time then?
8th, yes. 8 ওটা আপগ্রেড করে দেবেন। 8 তারিখে আপগ্রেড করে দেবেন।
Item 30.
হ্যাঁ 8 তারিখ করে দেবেন, উপরের দিকে করে দেবেন। এই আলাদা আলাদা করে দেবেন দিদি প্লিজ, ওই অপোজিট পার্টি আর আপনার পিটিশনার সব একসঙ্গে রয়ে গেছে।
Lordship,
তাহলে খুব অসুবিধা হবে।
Lordship, today's feast matter 3:30 matter. Tomorrow can Mr. Banerjee is here. No, tomorrow kindly feast top of the list. Let's say Mr. Banerjee is here.
When is your matter in the trial court?
But middle of June or I think so.
Not middle of June. You had said July sometime. I remember it.
Lordship, kindly fix tomorrow.
No fixing tomorrow. Tomorrow is the last date. Yes, yes.
13th.
That it will be there in the list.
Extension.
Keep order. Pension it, I'll upgrade it.
If there is no bench, then
if determination
Before vacation, nothing.
that's why I
will.
Careful.